Chief Justice Gertrude Araba Isaba Tokonu was suspended as a result of a prima facie determination by the Council of State as contained in the public announcement made by the executive. We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship Gabriel Scott Poama to trial the Chief Justice amounted to a travesty of justice.
Chairman. The removal our rules are clearly offended. Our rules are clearly offended because the rules I just read clearly offended. But the rules clearly are offended. Chairman, the rules say that the conduct of the speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except on a substantive motion. He has just raised the question of the conduct of a Supreme Court judge who chaired the committee. And he describes it and the conduct and what the Justice did as a travesty of justice. He has raised the conduct of that judge. He has. And the rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Chairman, let me respond to him.
In Parliament. No, this is a very, unacceptable conduct.
Yes, Honourable Minority Leader, you have the floor.
Mr. Chairman.
Seriously, they should go and address the press. They should go and address the press and stop this type of process.
Honourable members, order. Honourable woman, order.
Mr. Chairman, let me make these preliminary comments before I address.
In response to...
Yes, before I address, I've made an observation. The learned Attorney General knows how much I respect him. He knows how much I respect him. And this must be reciprocated by him. When the respected learned Mahama Yariga, leader of government business, was raising his objection, I remained quiet to listen to him because I know that decency requires that we listen to each other in silence. We are lawyers, and in the East, we must demonstrate that practice in Adaba for people to know that we listen and respond. So please, unless there is another plan that I don't know, but whatever that is happening today, history is watching. Now let me respond to my respected colleague, the majority leader. Chairman, it is his contention that my reference to the committee's work amount to attacking the conduct of its chair. With the greatest respect, I need to be listened to, and he has to pay attention to language as used in context. For the avoidance of doubt, I am repeating that the minority holds the view that the committee's work resulting in the removal of Her ladyship, the Chief Justice, amount to travesty of justice. It is a view we hold. It does not offend order 1237. Order 1237, with avoidance of doubt, provides the conduct of the Speaker, the Chief Justice, members of Parliament, the Chief Justice, and Superior Court Justice of Judicature shall not be raised in Parliament except a substantive motion. Now, the distinction must be made. Respected Ayarga, please, bear with me. I've listened to you. The distinctions must be made. Your work in the regular official duties and a critique thereto must be distinguished from personal conduct that one would consider as misbehavior or stated misbehavior. I am not, with the greatest respect, impugning the person of the reputation of my Lord Puaman, who I voted for under the influence of Honorable K.T. Amon. When all the odds were against him, I have nothing personal against him. Because even where there were personal issues that people were attacking his reputation, I was one of the few who stood.
Mr. Chairman.
So I'm not here to attack him.
Mr. Chairman.
And he knows I won't attack him. The caucus is talking about, please, Honorable Ayarga, let me finish. You were allowed to make your point.
Yes, but Honorable Minority Leader, just be brief.
Very well. The committee's work is what we are expressing an opinion on. And we are using very civil language to say that what it did amount to travesty of justice. It's as simple as that. So let me proceed. Chairman, unless the majority leader intends to frustrate everything that the minority has to say by way of its opinion, when did Parliament reduce to this? When you have the right to say your own, you are the leader of the House, you have unfettered right to rebut. That is the debate we even have on the floor. When there is a debate, you take note. Where you think you disagree, when it gets your turn, you should also say that the committee's work did not amount to travesty of justice. Simplicity. But this issue of one line, point of order, next line, you are marking, don't say this, don't say that. Where are we heading to? The judiciary criticizes the government and members of the public where they disagree in their ruling. We Honorable Minority Leader, kindly conclude for me. The work of even
please conclude for me. Conclude
so
for me.
I beg you, leader.
Conclude.
We all agree, Chairman. You
conclude.
know.
Conclude.
Right. So let me proceed.
Honorable members, I have listened to the majority leader.
Travesty of justice is now.
I have listened to the minority leader. Honorable members, we should be guided by the principles that if there is an issue on the floor of Parliament which has got to do with another who may not have the opportunity to respond to it, such a thing should not be made on the floor. Now, though Justice Gabriel Poma is here in person, at no point will he have the opportunity of responding to any issue raised about him. None of the committee members will have the opportunity here and then to make comments. Therefore, for you jumping into a conclusion to say that their reports amount to a travesty of justice without any of them having the opportunity to respond offends our rules. I will consequently order that anything in relating to the committee and justice format should be expunged from our record. That is my ruling. Kindly proceed.
Chairman, let me protest the rather unacceptable, consistent attempt by the majority leader to obstruct our side's remarks in this process. I know he's your leader, but Chairman, this is unacceptable. That said, I will proceed. Yeah. We hold a view that the removal of Her Ladyship Justice Gertrude Araba Isaba Tokonu was cloaked in some opaque circumstances unacceptable to the jurisprudence of
Mr. Chairman. Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Honorable Minority Leader, you know the rudiment of the game. If you don't want interruptions, let's go by the rules. Other than that, the chairman will be compelled to listen to the person and make ruling. Yes, Majority Leader.
Mr. Chairman. Mr. Chairman, if the minority, led by the minority leader, were to walk out here and invite all the journalists, they could describe the work of the committee in any language. In any language. Nobody. Freedom of speech. But before this Committee of Parliament, the rules are clear. What you can raise and what you cannot raise, and how you can raise it. I'll be surprised if after all these years in this Parliament, you don't understand those rules. I'll be surprised. Yes, I intend to be offensive because he has told me that I am here to deliberately obstruct the minority. What did you say about that? To describe my conduct here as deliberately obstructing the minority when I'm trying to keep him to the rules. When you say the conduct of a judge, we're not talking about the personal conduct, who he slept with and who he didn't sleep with. We're talking about his work, how he conducted his work. You are saying that the committee conducted its work in an opaque manner. That's what you are saying. In darkness, that's what you are saying. And that the outcome of their work is a travesty of justice. That's what I'm saying. And you are not in court challenging the conduct of the committee. You are not. You as a person, you are not in court challenging the conduct of the committee. You know the rules in the Constitution regarding the work of the proceedings. You haven't shown at any stage that the rules in the Constitution governing the work of the committee have been breached in any way. How can you come and sit here and describe the work as opaque, travesty of justice, and improper removal, and etc., and expect me to sit here and allow you to do that? You are clearly violating the rules. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honourable Majority Leader, you've made your point. And again, if I'm called upon to do a ruling, the rules are clear that we should refrain from the use of offensive language. We are here for the purposes of vetting. A situation where the process will be used to describe the work of a committee to be opaque, meaning it was done in darkness, is offensive. Therefore, I will order that same be expunged from the record as if it doesn't exist. Honorable Minority Leader, proceed.
Chairman, with respect.
Okay, thank you.
Chairman, with respect, he raised the objection. You didn't give me the opportunity to respond. And you're saying that you have ruled. I mean, what is the fairness in this? He just raised the objection. He didn't refer to any rule this time. This time, he didn't refer to any rule. And then he says that we should go and do press conference.
Honorable Minority Leader, kindly proceed.
Ask questions. Is that what they want to do today?
It is our contention that the process leading to the removal of Her Ladyship, Justice Araba Isaba Tokonu, was unfair, it lacked due process, it did not adhere to any constitutional procedure.
Chairman, I hope, Chairman, that persistently violating the rules of this House is a breach of privilege. You know that. Persistently violating the rules of this House.
Chairman, he's made a point. Let me make a point. With respect to you.
Honorable Chairman, if you can hear me out, yes, maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same or making same as a subject matter of discussion, with all due respect, this is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please let's refrain from all those things and be guided by our rules in raising our issues. Minority Leader, you just spoke about fairness. So is it fair that a committee that is not before us, their rulings are brought here and described in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided as such.
Mr. Chair.
Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this conversation, the vetting of the nominee, without reference. It appears that there is a gag order. Mr. Speaker, the minority will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is so. I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
With respect.
Honorable Tampuli. In this house, we play by the rules. Now, tell me, at vetting, in raising a preliminary issue, preliminary issues are not questions for the nominee to provide an answer. Then you bring the work of another committee entirely as a running member of defense and vetting, describing it in all sorts of ways. Should this be permitted or it should not be permitted? So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us. So I believe you agree with me that it is not proper by way of preliminary issue, a work done by a committee should be brought at the vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is re-litigating any issue. What the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. and it is the view of the minority, and I think that it should be allowed to learn, then the majority leader can speak. Mr. Speaker, I think that, look, if we are going to be too, more or less fastidious about what he's saying, we can't make progress. With respect, Mr. Speaker.
Honorable Tampoli, if you want to make progress, I think we can make progress. But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampoli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5 with respect, Mr. Speaker. Order 5.1. Subject to the provisions of this Constitution and any other enactments. Where there is doubt, these rules shall be interpreted by Mr. Speaker. 2. In any case not provided for in these orders, Mr. Speaker shall decide on the procedural question. And finally, 3. In exercising the power conferred under this order, Mr. Speaker shall act in accordance with the Constitution. So we think that what you are doing, yes, it may not be provided for expressly.
No, but what you are saying,
what you are doing amounts to being guided by Order 5.
Yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution,
so you agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law. And they say that, so, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in. And I think that you have to exercise your discretion to allow the minority leader to learn. Because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not here with a substantive motion to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with
Honorable Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule again, they are specifically and expressly provided for in the rules. In the rules. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to Order 24B and D. Mr. Speaker, with your permission, I read Order 24B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24 D have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote concessions on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and he correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker. Thank you.
Honorable Minority Deputy Whip. It is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The rights of those committee members are also supposed to be protected. So don't take it that I am violating the rights of the minority leader in any manner whatsoever. That will be a very wrong impression. And let me state that anybody who wants to enjoy his rights should know that the beginning of your right would mark the end of somebody's right. Thank you.
Chairman, and keep to the rules because I will object to anything that violates the rules.
Mr. Chairman,
Minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions. Our own Supreme Court, the High Court, and the ECOWAS Court of Justice now challenge the constitutional validity of that removal. Not one has been heard on its merits.
Mr. Chairman.
Yet, while these cases remain
Mr. Chairman,
while the very question of
I object, Mr. Chairman, I object.
There is a nomination.
I object.
Can have the floor. Honorable Minority Leader, hold it. Majority Leader,
Just walk out.
you said you object. What are you objecting to?
You are rehearsing to walk out.
Mr. Speaker,
Order.
Pending matters.
our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber, and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from random commentary on pending matters. We even don't refer to them. It's clear. I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this house, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are from your market. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standard orders anything that says that you, a your market, have a right to make preliminary statements. You don't.
Is that not something that
listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away once I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
Micro minority by Safa. Micro minority by Safa.
Yes, Honorable Anodongre, what do you have to say on the issue raised by the majority leader, Honorable Mahama Ayarga?
Well, initially I didn't want to comment. We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look that the Chief Justice nominee is before us and this whole process is being reduced into a banter between the majority leader? It's been reduced into this. It's most unfortunate. And I'm surprised at some of the issues being raised by the majority leader, saying that, show us the rules that says that when there is vetting, you should be allowed to make comment. We are not only guided by rules, we are also guided by practice. Show that every Friday you should be standing behind the dispatch box and presenting petitions. There are no rules on that. But it's part of our practice. The majority leader will respect you. You know this. So don't keep referencing that, saying that, show us the rules, show us the rules. It's not just about the rules. It is also about practice. Now, the very rule you referred to, 103, when you said it could be applied mutatis mutandi, I think majority leader, you are wrong. The rules were made with specific functionality, and the 103 you quoted is on admissibility of motion. No, it's motion. And it's giving us conditions for admissibility of motion. So when you read the heading, so you are interpreting the rule to suit your understanding. A while ago, Tampuri just referenced Order 5 and says that interpretation will be done by the Speaker. Allow the Speaker to lead the process. Allow the Speaker, the Chair, to lead the process. All of us are here to support, to make sure that these things are done. But the way you are positioning yourself is giving a wrong impression, and the public is watching. You will not even allow the minority leader to speak. And you are marking every sentence, and we are here saying that is normal. Why don't you take your notes when he's done, then you can present your version of the truth. This law teacher started marking his sentences long ago. I'm not the first person to mark his sentences. His law lecturers marked his sentences for years.
Anytime it appears to me, I'll conclude. Because you are pushing me to conclude, I'll conclude. But interestingly, the majority leader catches your eye every time. It is surprising that he always catches your eye. When we also draw your attention, let us also catch your eye. We also have something to say. Parliament is not just about the majority leader. For heaven's sake, I'm representing the good people of Insama Dredji. And when I have a view and I catch your eye, you must allow me to express him. I want to tell the majority leader, anytime he obstructs the minority leader, we will also obstruct him. No? Let him make his point. If it is the case that your strategy is that you are going to obstruct him, we will also obstruct you. And you won't make your point. But the begging question is, to what end? Are we going to conclude this vetting? What are we telling Ghanaians as representatives of the people? Speaker, I think you should rule on this matter. The majority leader should put down his point. Can I finish? For heaven's sake, can I finish? The respected majority leader I saw him taking copious notes. He should write down his points. And regardless of the fact that he's a majority, he's a member of parliament like anybody else. Let him write down his point. When the minority leader is done, then he can come in. Then we can make progress. This whole strategy of any sentence.
I would have been asking questions, but sometimes when I ask questions, they take it that I'm being sarcastic. I will give the floor to Honorable Roxanne from Obo.
Chairman, thank you for the opportunity. Chairman, given where we are, I seek your guidance on this matter. And here it is. Within the terms of Order 103, Rule D, Rule E, and F. The minority leader led a team of its members. They filed a motion. The terms of the motion, Mr. Chairman, reads as follows: that this Honorable House, having regard to Articles 110 clause 1, 125 to 127, 144 clause 1, and 146 of the 1992 Constitution and Standing Orders 57 Rules 1 to 3, Order 93.
Is that the motion Speaker rule on?
Yes. For the records, I'm reading the terms of the motion they filed. Yes. Order 103, Rule F, Order 216, and Order 217 of our standing orders resolves to suspend forthwith all further proceedings, both at the Appointments Committee and at plenary, on the nomination of Justice Baffoe-Bonnie as Chief Justice until all pending suits and applications directly bearing on the removal of a ladyship Justice Gertrude Araba Isaba Tokonu Saki Tokonu, including ECOWAS Court suit number ECW/CCJ/APP/32/25 on provisional measures, multiple Supreme Court proceedings, and High Court applications are finally determined or withdrawn, and that in the interim, the Business Committee reprograms the business of the House. Accordingly, the Appointment Committee stands down any scheduled vetting related to the nomination, and that the Attorney General and Minister for Justice be summoned pursuant to Article 103 of the Constitution to appear before this House or before such committee as the House may designate, to provide a comprehensive briefing on the status of all pending litigation relating to the removal of a ladyship Justice Gertrude Araba Isaba Saki Tokonu, including but not limited to A, the identity, jurisdiction, and procedural status of all such proceedings; B, any provisional measures, interim orders, or conservatory orders sought or granted; C, the relief sought in each proceeding and their potential implications for the office of Chief Justice; D, Ghana's international obligations under regional treaties relevant to the ECOWAS Court proceedings; E, the government's assessment of potential legal and constitutional implications of proceeding with the appointment of a successor Chief Justice while such litigation remains pending; and F, any other matters relevant to Parliament's informed exercise of its constitutional functions under Article 1141. Applicants of the motion.
Well, hold on. Let me hear you, Honorable Habib. What are you objecting to?
Chairman, Parliament and parliamentary proceedings and practices. A member is not to address the House. What Honorable Robson is doing is addressing us. Whatever he's reading, Mr. Chairman.
Honorable,
Mr. Chairman,
you are completely out of order.
To us, Mr. Speaker.
You are completely out of order.
So, Chairman, no, he should stop.
It is only when a supplementary question is being asked.
A motion that the Speaker has ruled.
Would you listen to me, Honorable Habib?
On the floor.
Would you listen to me? It is only when a supplementary question is being asked that you don't address the House. So you are completely out of order. Honorable Minority Leader, may I have your response?
Chairman, I'm not done.
Okay, hold on. Then conclude.
Yes.
Conclude.
No, I'm not done.
Then conclude.
So, Mr. Chairman, these were the terms of the motion the minority leader and his group filed. In the course of considering admitting this motion, Speaker determined that the motion cannot be admitted. Now, the minority leader, as ranking member of this committee, is using a backdoor approach. He has rehashed the terms of this motion, contained in a speech, and he seeks to read that speech before this committee. It cannot be done.
Yes, minority leader, let me hear you.
Chairman, with respect, thank you for the opportunity. Let me first respond to the issue raised by the respected majority leader, which issue he anchored on Order 103F. For the avoidance of doubt, I would repeat the provisions in the said order. A motion shall relate to a definite issue and not be the subject matter of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. These are my views on this. First of all, we are not dealing with a motion. But granted that, as he put it, this provision that deals with conditions of admissibility of motion should be read and construed within the context of my preliminary comment, then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters
Honorable minority
let me finish.
With all due respect,
You allow the minority leader. I'm responding to his
asking
objection.
the minority leader to raise any issue. Order.
I am responding
Order.
I'm responding.
Honorable minority leader.
Let me respond.
Honorable minority leader, hold it. Honorable minority leader, hold it. May your microphone be off, minority leader.
Chairman, just a second.
Minority leader, let your microphone be off. Hear me out.
Very well, I will hear you.
I'm supposed to play the fair game here.
If you make your point, we respond.
Honorable minority leader,
What is wrong?
Please, just observe me.
The Flamer spoke
Hear what I will want to say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not.
You said that. You've said that. You've said that.
Well,
You've said that. You said that. You said that the nominee swiftly empaneled the court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman,
I have the floor. You've not called.
Chairman, the rules.
You have not called. Chairman,
the rules.
Chairman, he puts on the rest.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear, Chairman. The rules. So when you just come see. You just put on your microphone and speak. You just put on your microphone and speak.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement. If we consider this motion, you shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it. Okay. Not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee, because for me, that matter procedurally and legally is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response. The Majority Leader has raised this issue, and then the Fiamako also brings in a different issue. So I'm done with him. Let me now address the Fiamako's issue, the Majority Chief Whip. The Majority Chief Whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that. Now, it does not stop us from stating our views. The Speaker's ruling at this committee, we know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the Majority Chief Whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the Majority Leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity. Because Her Ladyship Justice Araba Esaba Tokonu has right, far right. And what becomes of her when eventually the court determines that all her beliefs are upheld, yes. And then what becomes of us?
Yes, Honorable Majority Leader.
You are hearing?
No, I am the one speaking.
What do you
understand?
Yes.
Please, let's take a cue. Severally,
he has raised it.
I admonished
him or me
that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So, minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them Sunday. That is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt.
What is the problem?
They are in majority, no doubt.
This is a preliminary.
But they should allow us. I'm responding to you. See, Chairman, the
issue, but you can't be jumping from this issue.
Chairman, what the majority leader is doing is not fair. He raises his issues. You don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours.
Because
honorable members, order. When you are talking, honorable members, on this note, we will break for cocoa. So it's time for cocoa break.
Welcome back to the studio right from Parliament. And chairman of the committee said they're breaking for cocoa. It's been over an hour of exchanges between the majority and minority leaders in the House, and also the ranking and other members of the committee on the comments that the minority leader, Fenyo Markin, wants to make on the House in relation to former Chief Justice Gertrude Torkornoo. It's been a back and forth about her issues in court, but the chairman of the committee, or the majority leader for that matter, has insisted on rejecting the minorities leader's position. In fact, the majority leader, Mahama Ayariga, has insisted on the orders of the House to ensure that none of the court issues that have been proceeded or progressed by the former Chief Justice is stated in the House. According to the majority leader, per the orders of the House, no conduct of justices should be raised at the committee level except by a motion, or even brought to the House except by motion. But the minority leader, Alexander Fenyo Markin, continues to push that agenda towards. So we go back to Parliament and get to James Aveji to give us updates from the House. James Aveji, let's take it from where you are.
Man of the committee had called the House or the committee to order to begin the process, indicated that he wanted to do what he called an opening remark. For those who follow the appointment committee exercise, that is synonymous to Honorable Alexander Apenyo marking anytime any vetting comes in. And so when he began his initial remarks, he just at the start of his remarks indicated that And so the back and forth has led to some stalemate at the vetting committee here. Let me just run you through what has been happening. So the majority leader, actually, Mahama Yariga, just at the start of the minority leader's opening remark, raised an objection to a line in his remark that sought to describe the nominee, Justice Baffoe-Bonnie, as a disputed nominee, which the majority leader believes is against the House's orders, or Rule 103F of the Orders of Parliament, indicating that some of those words are not permissible and that they do not describe the character of the nominee in appropriate terms. He raised that objection, and then the minority leader came back to defend his position, and it led to another long back and forth. The chairman of the committee, Bernard Ahiafo, had to step in to call him to order, and then he allowed him to proceed. Then when he was proceeding with his opening remark, the minority leader, Alexander Apenyo Markin, again, as part of his speech, indicated that they, the minority, believe that the processes that led to the removal of Justice Gertrude Tokonu, he said, quote unquote, is opaque and is a travesty of justice. It drew the objection from the majority leader, Mahama Yariga, again, who insisted that those words are not supposed to be used. And at that point, Mahama Yariga then vowed that he will not allow the minority leader, Alexander Apenyo Markin, even an inch to breach the orders of Parliament so far as he is seated at this committee today, and that is what he's been living up to, raising objection after objection into the matter. The chairman of the committee, Bernard Ahiafo, made an initial ruling. He said that any issue that will be raised on the committee which has to do with the work of the Justice Scott Poamang's committee will not be allowed on the vetting, on the committee as part of the vetting process, because one, members of that committee or the justice who led that committee is not here to respond to some of those allegations, and so he will not allow them. Two, that is not the issue before the committee. MP Hassan Tampuli came in to indicate that the chairman cannot make that pronouncement when the minority leader is only referring to incidents that led to where we are now, where we are vetting a new Chief Justice nominee. And so he's basically laying background to the issues that had happened before that. But the chairman, Bernard Ahiafo, insisted that he will not allow for that. It doesn't seem to appear that the two parties, both the minority and the majority leaders, are agreeing on terms. It led to some, at a point, the two parties shouting on top of their voice, and the chairman of the committee has been compelled to, go adjourn the sitting for a while on what he calls a coffee break. I'm sure the two parties will be in conclave to deal with the issues to arrive at a consensus as to whether or not the minority leader will be allowed to continue with his opening remark. It is unclear yet as to whether or not the majority side would also, give up what their stance. We do not know, and so that's the what has happened, leading to the adjournment of sitting as we speak. I will attempt to see if I can get some comment from members who are here, of the public who are here monitoring the process. I see there the Deputy AG, Justice Ramsay over there. I see the former Attorney General Marietta Brew also there, and a number of the justices of the Supreme Court all there, having a chit chat as the House or the committee is on break now. Would attempt if I can get a word or two. They are having a conversation. He is there with Justice Atuguba, all having a conversation. And so that's what is happening now. The committee has gone on a break now. We'll be waiting for them to come back to determine whether, especially the minority leader, will be allowed to finish that statement that has brewed all the controversy that has led to the break. And so, Mami, if you're listening, that is the update here. It's unclear how long this break will be taking, but we'll be on standby to see whether they will come back, if the minority leader will finish his statement or not, before the vetting process actually begins properly. For 2 hours, this is what has been happening at the vetting committee, at the appointment committee here in Parliament.
Interesting exchange between the majority and minority leaders on the committee, but looking also at the nominee who is about to be vetted. How did you see his demeanor in that process?
Well, Mami, Justice Paul Baffoe-Bonnie does not look like someone who is worried at all about what has been happening. In the midst of all of the chaos, you will see him at a point resting his chin on his hand, or just sitting straight in his chair with his both hands folded and just observing what is happening. And so the nominee himself, from what we've seen, his demeanor at the committee, it does not look like someone who is worried or perturbed about what is happening. You could only see his colleagues who are behind him, only at one point or the other, getting close to each other, having a bit of conversation with each other. But it does not look like none of them, apart from the committee members, are worried about what is happening. And so he's been cool, calm, and collected throughout these 2 hours of the back and forth between the minority. But as to whether he's affected in any way by what has been happening, we would know when the vetting process itself starts properly, which will show in how he approached the questions and his mannerism to the answers to the questions when the vetting process now resumes in a short while.
All right, James, thank you very much for the updates from Parliament. We'll definitely get back to you when the vetting process resumes. And you're still watching Joy News here with live coverage in Parliament, showing you the vetting procedure of the Chief Justice nominee Paul Baffoe-Bonnie. We'll take a break. We'll return shortly when the vetting resumes.
So, Charlie, the deal there, I almost get her.
Syntax pipe.
You're so sorry with your back, sorry. Oh, what you was a thing. What the cat never won. Mitchell. Hey! Now I'm by.
Between a pie and carbon.
Hey, madam, bye, menu.
A sentence pipe. Metono, Omukacham send a word pa. Say a fee, say a foam. The other pipe we be a yen gum.
Syntax pipe.
Why only key?
Come, madam. From today, syntax pipe in my pipe. No 2 ways.
When you know, pipe ben abe use.
SINTEX pipe.
Syntax pipe.
In a carrier. No, hala.
How may I help you today?
We'd like to open a bank account.
Sign here, sign here, sign here, and here. And now you draw direction to your house. I need your thumbprint. And I'll need your birth certificate too. No, I need the original.
A lot has changed since you bank like this. So have we. We've made it easier than ever to open an account online and bank on the go through our mobile app, online banking, and more. EcoBank, a better way to bank your way.
Sign here, and here.
EcoBank, the Pan-African Bank.
This is the breaking news. About 2,500 people. 2,500 people have been.
We'll be right back after a commercial break.
When stubborn coughs, colds, and catarrh interrupt your life, get fast relief with Stop Cough. The Stop Cough range is suitable for adults, children, and babies.
In today's breaking news, Alex is back and...
There is a Stop Cough for every cough and for everyone.
There surely is.
Ask your pharmacist about the right Stop Cough for you. The Stop Cough range is manufactured and distributed by NS Chemist Limited. This advertisement has been vetted and approved by the FDA.
We all play differently. Some live for the thrill, some play chill. But it's the emotions that unite us. Bets for everyone. Reveal yourself. 1xBet.
Dreaming of your own home? Thinking of upgrading your space? Then it's time to stop dreaming and start building with the Republic Bank Love FM Habitat Fair 2025. From Thursday 27th November 2025 to Sunday 30th November, all roads lead to the Kumasi City Mall for the biggest housing event in the Ashanti region. Come face to face with the biggest names in real estate, banks with flexible mortgage deals, interior designers, home accessory brands, and the very best in building technology. Plus, don't miss our Habitat Mini Clinic where experts break it all down from the first block to the finishing touches. The Republic Bank Love FM Habitat Fair 2025. Financing your dream home. Inclusive, sustainable, and affordable living for all. Make a date and don't be late.
This event is in partnership with Republic Bank. Sponsored by DBS Industries, Syntax Tank, Doormaster, Ayuda App, Superlock, and Prestodia Ghana Limited. Supported by...
Hello, Ghana. It's time to celebrate 50 years of sports excellence. The Sports Writers Association of Ghana, SWAG, will honor and celebrate Ghana's sporting excellence at the 50th SWAG Awards in Accra. Date, Saturday, November 15, 2025. Venue, Accra International Conference Center. Time, 6 p.m. Theme, Gold and Glory. A call for change in national orientation and investment in sport. Special guest of honor, His Excellency John Dramani Mahama, President of the Republic of Ghana. Guest of honor, Mr. Julius Deborah, Honorable Chief of Staff of the Republic of Ghana.
Welcome back to Joy News. It's a live coverage of the vetting of Chief Justice nominee Paul Baffoe-Bonnie. But right about now, We'll be going back to Parliament shortly. It's currently on recess after a back and forth between the majority and minority leaders of the House on the word disputed nominee. But we'll get back to Parliament shortly. We have joining us this afternoon Andrew Ejapa-Mensah, who is a legal practitioner and also former second-D MP, former Deputy Energy Minister and former Tourism Minister, joining us in this discussion, and also Clement Akolo, he's Communications Director of Parliamentary Network Africa. We're grateful for your time on our coverage. Let me start with you, Andrew Ejapa-Mensah. This to you is not really new, but with this protracted conversation about disputed nominee, how does this come across?
Let me say good afternoon to your good now cherished viewers. Yes, it's true. It's not new. We would expect to show our country between two sides of the political divide on an important occasion of the Chief Justice of the Navy. But it's rather surprising to me that NDC majority, in spite of the fact that they have the numbers, they can vote on approving the Chief Justice, are just not prepared to let the minority leader vote. There's as far as we concerned, the cardinal rule of democracy, especially in parliamentary democracy, is that the minority will have and majority have it. So I feel why allowing read the preliminary, if you have, then you ask rather spend power go if this box minority deliberate very comment for them. How new? I don't.
Mr. Ejapa, can you kindly reposition yourself? I'm having difficulty hearing you, and I guess my viewers as well. But
yeah,
yes, you are saying.
Yeah, I'm saying that.
Well, we're still trying to establish a great line to Mr. Ejapa-Mensah, but let's go to initial comments.
All right, thank you very much. We are here once more. You know that it was the same vetting process that gave us the issues that we had some time ago, of which we are petitioning Parliament for a decisive decision should be taken on this particular matter. But we know that Parliament is the platform where the political statements are made, where, it's at the pinnacle of political game. And we know that this is part of the process of playing that particular political game. But we think that at a point in time, we should be mindful of the platform that we have and make sure that we are able to push through the national issues to a particular conclusion. This morning, we are watching this particular situation with a very, very, very heavy heart. I don't know the words to use right now, but we have continuously seen that the temperatures are rising. The situation, if not properly managed, could get out of hand. And we have been at preliminary stage for over 1 hour. And even the nominee hasn't even mentioned his name. And we don't know what is going on. And we think that our members of parliament are people of reason, and they should know that the whole nation, and as the chairman said, the whole world is watching us. If we cannot take the process of vetting a step further, then we don't know why we are there to do a particular work.
Well,
because
Can you conclude that point?
Okay, because the whole nation is waiting for a vetting to be done on a nominee to head our judiciary. Now the stage has become a banter for procedural matters and political discourse and banter. I think that we could do ourselves better than what we are doing now. So we are hoping that now that they've gone on this short risk test, they will come back refined, make sure that the procedures go through, and ensure that their political matters are put aside and dealt with at another appropriate place, which will be the chamber of the House.
Well, thankfully, we're joined again by Mr. Japah-Mensah. You've been in the House, and we often see these exchanges, heated exchanges on the floor of the House. We know that the orders of the House are equally important. But on the committee level, like this, with such protracted arguments, going back and forth on what the procedure should be, looking at the posturing of both leaders in the House and even the chairman in adjudicating this process, what do you make of it? Is it right? Is it fair?
Giving the minority a fair deal. And I'm not saying so because I belong to the NPP. Look, this whole process of appointment of a Chief Justice is a political process. Parliament is a house of record. And so if the minority has any position, it is only proper that they put it on the record. Okay? So that posterity can have the benefit of what transpired during the vetting of the Chief Justice. So I would have thought that because there's already a precedent that has evolved since 1992, the majority will allow the minority to make their points, to seek to want to prevent them from doing so, to seek to want to put impediments in their way, is what is dragging the process. And I don't think that is helpful for the Ghanaian people who are spending precious man-hours waiting to watch the vetting proceed. And so I would think that we should call a spade a spade. What the minority, of course, they have the numbers, and I agree that at the end of the day, it is the numbers that will make a determination as to whether the Chief Justice is confirmed or otherwise. But allow them to make their points. That's the beauty of democracy.
Of the House, and you raise it, and also the majority leader raises the issue of Order 237, that the conduct of justices of the Supreme Court and also the Speaker isn't brought to the House except by motion. You know, all these points have been made, yet minority leader insists on pushing through with that statement, which has already been dealt with the House.
From what I said, they are red herring. Okay? No substantive matter regarding the conduct of the committee has been put in issue. In any event, people are entitled to their own opinion. And so, if they make the point that as far as they are concerned, the processes that led to the removal of the Chief Justice, as a background, narrating the facts as we all have read, seen, observed, how is that wrong? How does that put the conduct or the integrity of the justices of the Supreme Court who sat on the panel into disrepute? With respect, I fail to see that the points that the majority is making can be sustained. It's just not right.
But also, so he's also...
The reason why the minority will have its say is to allow them a platform to amplify their view. And then the decision is taken through a vote. And you have the numbers. So how can't you allow the minority to speak and add their views on what they see to be the case relative to the appointment of the current Chief Justice?
But also the point about the members of that committee or that probe aren't present, cannot answer for themselves. You know, when the minority leader began with the committee, the Puaman committee, and the processes that went through with former Chief Justice.
This is an agitatory process.
So
where you would say that one party is not present and you are making an allegation against them. And so to the extent that they do not have a right to respond, don't make a comment.
Well, the minority leader mentions situations as in they proceeded in an opaque manner, and even some travesty of justice, making such comments. You don't think they should have?
But we come on your TV and your platform every day to air our opinion. That's exactly what we're doing right now. It's not an adjudication. It's a parliamentary hearing to establish the capacity of the Chief Justice to occupy the position that he's been nominated to by the President.
Okay.
As a form of background, the minority says that, look, we have a problem with the process that led to the appointment of Justice Baffoe-Bonnie. And so we are going to make preliminary comments in that regard, just so that Ghana can capture it for posterity. How is that an adjudication that then says that, well, the comments that you are making affect somebody who is not here, and we cannot give that person a right to be heard, and so don't make those opinionated statements? For the life of me, I cannot understand.
So now we look at this being going on for 2 hours. How do you see the posturing of the chairman in dealing with the issue?
I hope that they've gone into conclave to have a discussion between leadership on how to proceed when they return. And from where I sit, if the two leaders take the entrenched position that, look, we want to make our statement regardless, and the majority takes the position that we're going to object to every line regardless, then it's going to be a long, drawn-out process. Because I don't see the minority walking out. If they do, then that leaves the floor for the majority to do whatever that they want. They can even probably proceed to vet the nominee in 10 minutes, like happened in the past when some ministry appointments were done in 10 and 15 minutes. Okay? If the minority decides to stay in the room, then there's going to be a stalemate, because the minority will insist on having their say so that the process can continue. And I would think that in a decent democracy, the majority will accommodate the minority to have their say so we can make progress.
But Mr. Japamesa, is it also not fair that this same issue was raised in the House and concluded upon by both speakers of the House, Mr. Alban Bagbin and also Ahiafo? Why then do you bring the same issue on the committee?
But of course, the parliamentary plenary setting is completely different from the vetting. The vetting has the nominee present. The nominee was not in chamber. I am not even aware that the issue had come up at plenary. Many Ghanaians who don't follow parliamentary process will never know. And so to make it part of your preliminary comment at the end, to draw attention of Ghanaians to what is prevailing at this moment, I don't see anything wrong with it, in all honesty.
Okay.
Because, Mamiesi, you would agree with me that, like I said from the very outset, this is a political process.
Right.
And so the minority is entitled to do the politics and make their political statement for Ghanaians to appreciate in context what the issues are. I frankly cannot see why we cannot allow that process, which, for want of being repetitive, has been the practice since 1992. How is it not going to be accommodated today?
So your point of view now is that the chairman has to allow the minority to make their statement.
Read whatever he wants to read, and then if the majority wants to respond, you give them an opportunity to respond through their own preliminary comments if they so wish. So we can go with the best.
All right, kindly stay with me. Let me go back to Mr. Akolo. Mr. Akolo, so how do you navigate this? How does Parliament navigate this, especially the chairman with two strong sides who are both willing to budge? But I'll come to you. Let's go back to Parliament. There seems to be some development there. We'll go there and we'll be right back.
And fourth, the nominee is yet to, the interrogation is yet to start here at the Parliament Appointment Committee. As you see, the seat here are deserted as we speak. The members of the committee are yet to come back from that break, and we're waiting for them to come back and continue with the proceedings. But let's pick some more reactions from the MPs on what they have been making out so far about what's been happening. The MP for Guan is here, Honorable Fred Agbenyo. Honorable, thanks for joining us. Let me first get your initial reaction to what has transpired in the last 2 to 3 hours at the committee.
In one word, if it's annoying, what is going on is very, very annoying, very irritating. You know, we are here for serious business, and so it's sad when some persons want to reduce it to drama, some theatre, some comedy. You know, this is serious business. We are vetting the Chief Justice of the Republic of Ghana.
Is that what you describe it as, drama and theatre?
Drama, it is theatric. Nothing but just that. Drama, complete comedy, nothing else. What is it that he's been saying for the past 2 to 3 hours that I didn't say on the floor of the House? What is new? Is it the first time in the history of Ghana that the Chief Justice will remove from office? Is it because somebody is your darling girl, and because your darling girl has been removed, you are so peeved? You cannot come to terms with the reality that this country is governed by law, and that's the same constitutional procedure or processes that you use in removing the former EC boss that has been used in this case. Has he been able to point out to anywhere the Constitution has been infringed upon, or anybody has acted outside of the Constitution? That the President received a petition, he forwarded the same to the Council of State. Council of State established a prima facie. A committee was set up. Committee did their work and brought their result. Based on that, a decision was made. You say you don't understand? Are we governing this country by people's emotions or people's understanding? Why is it that some people think that they are superior to the rest of us Ghanaians? Why is it that people think that they are superior to even the Constitution that establishes our democracy? And that all of us must do that which pleases them alone. If they don't want to be part of the can walk out.
There are those who also accuse your side of the committee of being responsible for this. If you had allowed him to land with the minority leader to land with his statement, we could have made progress.
If somebody is engaged in wrongdoing, we have standing orders that guides and regulates our activities as a house. And if somebody is operating outside of the law, should we sit back and fold our arms and watch him? Because he's who he is, we must allow him to say whatever he wants. Is that what you are suggesting? No. We are governed by law. And so if you are operating outside of the law, somebody must draw you back. If you are refusing to do the right thing, so how can you say it is our fault?
So how do we resolve this? Because it appears that the back and forth, you are wrong, I am not wrong, will not let us proceed. We've wasted about 3 to 4 hours.
Well, the truth is that we are going to vet the Chief Justice nominee, and we are going to go through the process. Very soon, if they will not allow the process to continue, you will see how we'll end it. But the assurance I can give is that we'll do the vetting. It's either the sitting will do it or
with or without the minority.
Why? What are they adding to anything? The people of this country went to elections of 2024 and gave us overwhelming majority with the hope and belief that whether they are there or not, we should still be able to govern this country. We should be able to make laws for this country. That is why we have to test in Parliament. And so we don't necessarily need them to be able to carry out any business in this house. We believe in multi-party democracy, and that is why we will tolerate and encourage some of this thing to go on. It is not because we are weak as a political party and the impression that is created out there because we sit back and watch all this theater and drama goes on television, and some people think that the NDC side we are weak, and that's why no, we are not. Sometimes for the peace of this country, that's why we are able to tolerate these things. Not because we are weak or we cannot stand up to these things and challenge these things.
But why is the speaker hesitant in taking a decision on this? Some expect him to stand his grounds and take a decision to determine whether or not the minority leader can go on or should stop the statement.
Well, every leader, has his limits. A speaker, if you have said the speaker over the period, is able to tolerate, is able to watch, able to give a room for people to operate. By the time will come when he put his feet down and do what the larger community is expected of him. I will not be surprised that when he comes back, the approach will not be like what we saw before we went on recess.
And you expect the matter to be resolved? Resolved in a way that the minority leader's speech should have been edited, or he should discontinue the speech?
The whole agenda is he wants to look into the face of the nominee, tell him his peace of mind. When they finish, then they will walk out of the process. That is what they want to do.
You suspect that
this agenda that they are putting, as I said, it is theater, it's drama that they are doing. Nothing good for this country. And we don't need to tolerate these things.
I see. Thank you so much. Fred Agbenyo there. He is MP for the Guan constituency, and he believes that this is a theater and drama staged by the minority in order to deliberately to the vetting who are currently seated. You see the justices, colleagues of the Chief Justice nominee, seated there, also following the process. I would attempt to see if I can get some more reactions from a number of persons who are here monitoring the process. Chiefs, respected members of the public, also here monitoring the process. Let me see if I can speak to any of them. Council, just want to have a quick reaction from you. Just a quick reaction on how far we have come. 4 hours. This is how far the process has brought us. What's your quick reaction to what we've experienced so far?
Tell me yours. We have all been here. Let the process proceed, and then when we are done, we'll make our comments.
It seems not to be making progress. What do you expect when we return?
It's part of the progress. We are on break. It's part of the progress and the process, as far as I'm concerned. So let's wait till they recall, and then we will continue with the process. When we are done, then we can give our own views on what has happened.
Okay. You are here to throw your solidarity behind the nominee.
Well, I'm here in fulfillment of a constitutional provision.
Thank you.
Thank you.
Lawyer Opong there. Okay, he speaks for the venerable Lawyer Opong. They just gone director of the Ghana School of Law there. He said he does not expect much. He expects that when Parliament comes back, they would proceed with the vetting process. Let's see if we can take some more reaction from the people who are here to monitor the process. I see a chief here. Nana, good afternoon. Is it a good time to just take a quick reaction from you? You've been monitoring the process so far. A quick time to take reaction.
No comment.
No comment. Okay, thank you. Nana said he does not have any comment on the process. Earlier, I tried to speak to some of the justices. They would not make any comment on what has been happening so far, but we are still waiting on the committee to return to see what decision they will come with. You see there, the majority leader, Mahama Yariga, has returned now, and he is on his phone. It is unclear whether a decision has been taken on the matter yet, but the majority leader, who has been also at the center of the back and forth, is back. He's seated there on his phone, waiting for the members of the committee to return. For those of you who just joining us, this is our live coverage of the vetting of Justice Paul Baffoe-Bonnie, who has been nominated as Chief Justice for the Republic, and his vetting process ongoing. The minority and the majority have been back and forth, up in arms with each other. The majority leader, during the opening remark of the minority leader, Alexander Penyumakin, raised an objection to the use of some language he said are unparliamentary against or Rule 103F of the orders of the House, and he was of the view that those comments, for instance, the minority leader in the initial part said that the nominee is a disputed nominee. He take objections to that, and that the process that remove Justice Tokonu from office is opaque and a travesty of justice. Those are the objections the majority leader has been raising to the minority leader's initial comments about the process. It led to a back and forth. The chairman of the committee had to step in, made an initial ruling insisting that no reference should be made to any matter that is not before the committee, either the work of the committee that removed the Chief Justice, the former Chief Justice. He will not entertain any of those at the vetting process. And so that's what has been happening. We're waiting for the committee to resume, to come back and continue with the process. Beacon views, the MP for Guan, for instance, believes that this is theatric, this is pure drama unfolding. It is a tactics by the minority to frustrate the process, after which they will stage a walkout. That is his assertion and understanding of what the minority have been up to so far as the vetting is concerned. We're waiting to see whether that is really the case and if the minority would stage any form of walkout. Let me try and see if I can get some more reactions from those who've been following the process so far as the vetting is concerned, sir. Okay. Sir, I'm sure you are also here following the process. Just to pick a quick reaction from you on what. I'm sorry.
I can't make any comments for now.
To support the nominee?
Yes, please.
You are here to support the nominee?
Yes, please.
And the process hasn't started. What are your expectations?
I hope that when they return, everything will be okay.
Are you worried about what we've seen?
No, not at all.
You are not worried?
I think it's part of their proceedings, so I'm okay with them.
Okay. So if they return, you expect that the process would go on smoothly?
Exactly so. I'm expecting that when they return, everything will be okay.
Is it possible to know which of the institutions you're coming from?
I'm sorry for now.
Thank you. And so that's his view. He's not bothered at all. Sir, I'm sure you're also here supporting the nominee.
Yeah, really. Yeah. But I believe that the leader or the speaker is supposed to take control, instead of the minority giving their views and also the majority also giving their views. Other than that, it's not going to go nowhere. Instead of addressing the whole issue about vetting, they're talking about, the former Chief Justice, So it's supposed to make sure that the whole thing goes through the normal process. So that's what I can say.
Which means you are not clearly happy with what we've seen?
Yeah, because the most important thing is about the vetting of Justice Baffoe-Bonnie. But right now, it's like it's going back and forth between former majority, right? Instead of addressing the whole vetting issue. Because for almost 2-3 hours, we've been sitting here without hearing anything about, the proper vetting. So...
You believe the speaker hasn't taken a strong stance to exercise?
He's trying to do, but it's coming from both sides. The minority, the way he started, that's why the majority also didn't want him to go further, so he wanted to interrupt him. So I've been watching the whole thing. So all that I can say.
As a citizen, someone who is out of parliament, does this create any impression about the House?
Okay, it's okay. Now I don't want to say anything no more. I just want, them to use their normal process. I don't live I'm from United States, so I know how it works. But in politics, each and everyone wants to say what is, that benefits the other side, So you have to give the speaker the right to let us proceed, Thank you very much. My name is Kwabena.
Thank you. And so that's one of the members of the public who are here to support the nominee as part of the vetting process. Some more persons here. Good afternoon. Is it a good time to?
No comment. No comment.
Okay. And so those are the reactions coming in from people who are following the process and are here still waiting for the House to come back and continue with the process. We're still waiting to see what decision the committee will take coming back to come and continue with the process as to whether or not the minority leader will continue with that statement or not.
So that was my colleague James Aveji interacting with some members in the House and those that have come to support the Chief Justice nominee who is yet to be vetted. I mean, we all know of the back and forth that had carried on for 2 long hours, and they are currently on a break. They will subsequently be returning to the House, hopefully to resume vetting of the Chief Justice nominee and not another banter. But still with me are Andrew Ejapa-Mensah. He is a former MP and also a former Deputy Energy Minister, as well as a former Tourism Minister. And also joining me is Clement Akolo. He's the Communications Director, Parliamentary Network Africa. And just before we left off, Clement, I was asking you how we should resolve this situation when the vetting process resumes. Clement with me. Clement Akolo, if you can hear me, I was asking you how we move forward from this banter in Parliament, I mean.
All right. Thank you so much. This is a very, very difficult situation. You know, because the chairman has a very difficult task at this moment. If we have to move past this and then go to the real vetting, what it will mean is that the minority leader would have to move away from the statements that he's making, which is causing the problem for the majority leader, who is also intervening, to stop intervening. But the hardest part of the issue is that the minority sees an opportunity to make a point, to draw their blood on the issues that they have raised on Justice Tokono and the issues that they think that are not fair to their are not fair to them, in their opinion. At the same time, some of the issues that they are raising offends the standing orders of Parliament. So once that offends the standing orders of Parliament, it becomes difficult for the minority, the chairperson, to allow those things to go without any questions at all. So it becomes difficult for us to have a peaceful discussion. But I would expect the chairman of the committee to stay his ground, make sure that the two people are brought to some kind of agreement while they are on recess, an agreement that you cannot go this far and you two don't interrupt at this point of view. Let's agree that this is a political platform. Yes, the minority would have to have its say somehow. But minority, have your say, but stay within the rules. And then majority, allow them to have their say at this point, so that your nominee that has come would get his vetting, and then you get out of here. Because as a majority leader and leader of government business, your interest is most for your work to be done and then done away with. So that sometimes you allow a little concession for political statements to be made, albeit not to offend the rules, and then you have your work done. You know, it's a very, very difficult situation, because it is political platform. And when politicians see an opportunity to make political statements, they take full advantage of it. And at this point in time, the minority doesn't have a lot to lose, but it is rather the majority, I will say, that have a lot to lose, because the more the issue drags, the more time it will take, and we might not finish the vetting of the nominee today. And that will feed into the position that the minority leader took last Friday and said that the vetting will not come on. So if the majority leader does not play to the books of the minority, then we'll have this vetting going. But if he does not look beyond the issues that are playing now, it means that what the minority leader said the other time is what we are going to have.
Well, Mr. Japamesa, let's look at the rules, the procedure coming into the committee processes. What really is the routine? Because often, more than not, we seem to have this back and forth between the minority leader and then members of the committee, or even between him and the chairman. Is there any, rules of engagement that they need to meet, discuss something before coming to the committee level, so that there's some form of smooth process?
Ground rule, okay, or how the process will evolve in the course of the day. And clearly, if you follow the proceedings at the very beginning, the chairman given the minority leader an opportunity to make his preliminary comment suggests to me that that was something that had been agreed prior to the commencement of the day's meeting. Okay, but a few things that Clement raised, and also the comments that I heard Brother Gagnon make, okay, that I would like to speak to if you permit me. Clement, I mean, I fail to see why you would think that the minority leader has to move from his position and so that the process can proceed. I don't think so at all. Like you yourself admit, this is a political process, okay? And we all know that with the kind of numbers that the majority have, the Chief Justice nominee will go through, even if it's put to a vote, even if it's not by consensus. But to suggest that the minority should abandon the platform to make a statement that will go on the record, I don't think that is tenable. It's rather the majority leader who has to allow the process to flow, allow the minority leader to make his point, so that, like you said, as leader of government business, their business can proceed. And perhaps not say what? That because they have some super majority of sorts, like they are up to say that the country belongs to them or what? And that because of that, the minority have no role or say in our governance architecture. Is that a suggestion? Or they think they will have this normal perpetually? The 4-year cycle, let them remember that in 2016, the NPP had 169. At the time, it was unprecedented. Only 2 elections down. We are where we are. So let the NDC not think that because they have a certain number today. In any event, all you need is 50 plus 1 to take major decisions in Parliament. You don't need 108. Okay, all you need is 138. But it's important that to preserve our democracy, we allow the system that we have agreed to use as basis for governing ourselves to function. Okay? So let it not be said that because they have a certain number, and to suggest that people are, look, I'm in a very difficult situation, I must admit, because I know all the players involved in this matter. I know the former Chief Justice or the removed Chief Justice personally. I have a very personal relationship with the Chief Justice nominee. Okay, and so let's not be tempted to make statements or comments that would ruin relationships. But the truth of the matter is that they are all competent. The current Chief Justice is a very competent individual, fit and proper to occupy the role. The minority has an issue with the process. Why can't we allow them to air their issue so that the process can continue? And the tip for where they're going to go. What is too much to ask about that?
But Honorable Japa Mesa, I mean, you now former MP, the issues have been raised already. This is not the first time the issue is being raised. And the chairman has ruled on the matter consistently. In fact, made several attempts to tell the minority leader to discard that issue and proceed with his questioning, but yet insisted on that.
Discard what?
His issue of the court cases that are still pending.
But he made reference to the court cases because of the objection that Honorable Dofia Mapo brought in. But I'm saying that the substantive matter before us, which is delayed, is that the minority is making a preliminary comment. Why can't we allow them to make their comment?
The comment is what the majority have issues with, which the chairman has also ruled on. So why wouldn't the minority...
In the democracy, I'm coming. In the democracy, where political statements are allowed, what is the difficulty in allowing the minority caucus to make their political statement so that if you have any response, you can respond? Because look, let's not be fair that they are in breach of any rule, because I don't see it. All the rules or orders that were cited by the majority leader are neither here nor there. Just as not a motion. Is it a motion? Preliminary comments become a motion when?
So you also
discourage the obstruction. Let them make their statement. There certainly will be an opportunity for the majority to also respond if they so wish, so we can make progress. How is that difficult? Unfortunate.
Well, you keep referring to democracy, but in looking at what the chairman did, the chairman also gave opportunity to all sides to air their views.
But has the minority been allowed to air their views? From what you observe from the proceedings, has Afenyo Markin been allowed to make his preliminary comments and conclude?
Which the chairman has given reason to, that same issues that he raised has already been dealt with, so he should proceed. He should move on away from that.
The chairman's so-called ruling were as a result of the interjection by the majority leader, true or false?
Well, that was also made.
I'm coming. Is that the case or not?
That was made as well.
So I'm saying that why can't we, the majority, allow the minority leader to make his point?
Well, that's the decision of the chairman, and the chairman insists that he's not going to make it.
I don't have a difficulty with that. I disagree with the chairman. I disagree with him. But he's entitled to his position. I'm saying that if the minority leader is making preliminary comments, we cannot tolerate and listen, so that if we have any response, we can put up when he's done. We cannot. Come on. That is what is playing out. It is the majority leader interjecting and objecting to every single statement that is made by the minority leader. That's why we are where we are. Is that not it? Mamiesi.
Mr. Jaffa, I'm listening to you. Let's move on.
In the committee room.
Please go ahead.
Look, everybody knows in this country that the process that the NDC set out to achieve when they come into government, they will achieve it. They were already halfway there. I don't have any problem. It's prosperity that is going to judge all of us. But if the minority has an opportunity to put it on record, nobody is going to stop them from doing that. And I'll be extremely disappointed if the honorable minority leader abandons court and not complete the delivery of his preliminary comment. Because that's the essence. That you allow the minority to have their say. Look, the other time I was listening to Hakeem Jeffries, the minority leader of the House of Representatives in America. He delivered a statement that lasted more than 40 hours or so. Did anybody prevent it?
I'm listening to you. I want you to make your point, please.
For making his statement. So why do we want to change the rules when it comes to Ghana? Why can't we allow the minority leader to make his statement and to give an opportunity to the majority leader to respond if his own wishes? After all, we are all defending. Ghanaians are defending. If Afenyo makes any statement that is erroneous, Mahama Yariga will have the opportunity to set the record straight. True of all. Yet, we have become so intolerant because, according to my good friend who just spoke in Parliament, Fred Agbanyo, that they have supermajority and they can do whatever they please. Hey, let's watch it all. Let's watch it.
All right, Mr. Japamesa, would you like to speak to that, Mr. Akolo? Mr. Akolo, do you think the democracy in the room was not adhered to? Unfortunately, we've lost Mr. Akolo there. Mr. Japamesa, we're grateful for your time for joining us in this discussion. This is a live coverage of the vetting of the Chief Justice nominee, Paul Baffoe-Bonnie, and we're still here on Joy News. We'll be going to Parliament when the vetting process resumes. We take a break. We'll return shortly with a profile of Paul Baffoe-Bonnie.
Hello, Ghana. It's time to celebrate 50 years of sports excellence. The Sports Writers Association of Ghana, SWAG, will honor and celebrate Ghana's sporting excellence at the 50th SWAG Awards in Accra. Date, Saturday, November 15, 2025. Venue, Accra International Conference Center. Time, 6 p.m. Theme, Gold and Glory. A call for change in national orientation and investment in sport. Special guest of honor, His Excellency John Dramani Mahama, President of the Republic of Ghana. Guest of honor, Mr. Julius Debra, Honorable Chief of Staff of the Republic of Ghana. In attendance, Mr. Gianni Mello, President, Association of International Sports Press, AIPS. The prestigious and longest running awards event in Ghana, the SWAG Awards, promises to be an unforgettable night of glamour, excitement, and celebration of Ghana's sporting achievement. Performing is Afro-pop and dancehall star Stonebwoy. Come, let's celebrate our sports legends and honor the best to inspire the rest. For sponsorship, contact 050-701-7001. The 50th SWAG Awards, sponsored by GCB Bank, Gold Board, Tobinco, Stanbic Bank, Ghana Free Zones Authority, National Petroleum Authority, Omni Basic Bank, and Phoenix Insurance.
Dreaming of your own home? Thinking of upgrading your space? Then it's time to stop dreaming and start building with the Republic Bank Love FM Habitat Fair 2025. From Thursday, 27th November 2025 to Sunday, 30th November, all roads lead to the Kumasi City Mall for the biggest housing event in the Ashanti region. Come face to face with the biggest names in real estate, banks with flexible mortgage deals, interior designers, home accessory brands, and the very best in building technology. Plus, Don't miss our Habitat Mini Clinic, where experts break it all down from the first block to the finishing touches. The Republic Bank Love FM Habitat Fair 2025. Financing your dream home. Inclusive, sustainable, and affordable living for all. Make a date and don't be late.
This event is in partnership with Republic Bank, sponsored by DBS Industries, Syntex Tank, Doormaster, Ayuda App, Superlock, and Prestodia Ghana Limited. Supported by
When lithium was discovered in Ewoya, hope erupted. Ghana stood on the brink of a new future.
We saw it like a game changer.
He's going to provide us a lot of jobs.
Unfortunately, we didn't hear from them again.
It is making some of us like we are liars.
Parliament has not ratified the project, and for 2 long years, everything has stalled.
2 years deprivation, no farming, no building, no project. Everything is no. This is the genuine cause of the delay.
Livelihoods frozen, settlements on the brink.
I cannot even describe the extent of my disappointment.
The aspect of the majority.
We don't have the numbers. If they want to pass it, they'll pass it.
And the aspect of the stranded assets.
If we don't mine it quickly, otherwise, if time passes by, we have what we call stranded assets.
Do something now.
A promise made, a future delayed. Can Ghana afford to pause as the world races for lithium? Hope on Pause, the Lithium Promise, a Joy News Energy Desk series starting 10th November 2025. When lithium was discovered in Ewoya, hope erupted. Ghana.
Your Majesty, peace, security, and the fight against Galamsey are not separate stories, but threads of one national fabric. When one is torn, the others unravel. A polluted river is not merely an environmental concern. It is a quiet threat to peace itself. For where hunger flows, conflict often follows. And when our forests fall silent and our farmlands sink beneath the mud and mercury, we lose more than trees and crops. We lose our very livelihoods, our dignity, and the promise of tomorrow. This is why the fight against Galamsey is not simply an environmental campaign. It is a moral struggle for the soul of our nation, a struggle between short-term good and long-term survival. Dr. Kwame Nkrumah once seen the truth that the gold we dig so recklessly from the belly of the earth may yet bury our children's tomorrow. Our rivers no longer smile. Their waters have turned the color of sorrow. The children who once fetched water from them now dig into their banks for specks of gold. Schools now stand half empty, and the laughter of learning has been replaced by the clinking of metal on stone. Our nation stands at a defining moment where peace and security must not be taken for granted, and where the future of our environment and indeed our children hang in the balance. Illegal mining, or galamsey, remains one of the gravest challenges confronting our country. It has destroyed our rivers, poisoned our soil, and displaced communities. But beyond the visible scars on the land, galamsey represents a deeper wound, a failure of collective responsibility.
Welcome back. We just heard from the Chief Justice nominee, Baffoe-Bonnie. He spoke at the just ended Ghana Journalists Association Awards, and he's making very bold statements about the fight against illegal mining, that galamsey is poisoning our rivers. Peace and security must not be taken for granted. And we're hoping that, when the vetting resumes, these are some of the topics that will be coming up at the vetting committee. But Akolo is with me right now. Mr. Akolo, we're grateful for staying with us. We have been speaking on the processes that have led to this point, where the committee is on recess currently over the issue of disputed nominee used by Minority Leader Afenyo Marking for the Chief Justice and nominee. And that wasn't taken well by the majority side. The Majority Leader, Mahama Yarga, shut it down and insisted he wasn't going to allow the Minority Leader continue with that statement, and that led to a banter for almost 2 hours. Well, Mr. Akolo, we're still here debating what's going to happen next, the vetting, but I just want you to tell us a little bit about what you think about the Chief Justice, and he's already making statements about the galamsey fight, or illegal mining. As we all know it, it is destroying our river bodies, destroying our crops, our lands, and currently it's becoming difficult to curb the menace. We unfortunately have lost the Parliamentary Communications Director for Parliamentary Africa, and Mr. Akolo will join us shortly on the line later. Let's go back to Parliament and find out what's happening now. James Avajit there, standing by for us. James.
And the members of the committee are gradually returning to take their seats here. I see the Majority Leader, Mahama Yarga, together with his Majority Whip, Honorable Roxanne Nelson Dapamekpo, all seated, waiting for leadership of the committee to return for the proceedings to hopefully begin. A number of them are returning now after that short break taken by the members of the committee to possibly go and resolve the issues that has been happening here during the vetting. The proceedings started at exactly 11:45 a.m. and we're expecting that it would have been a smooth process. That wasn't the case, leading to a back and forth, a controversy between the two sides of the House, both the majority and minority leaders, Mahama Yarga, as well as Honorable Alexander Afenyo Marking, all caught up in that confusion and state of disagreement with each other. The Majority Leader Mahama Yariga's position has been about some words in the Minority Leader's initial opening remark or presentation, which seek to describe the nominee, the Justice Paul Baffoe-Bonnie, as a disputed appointee or nominee, and also goes on to describe the processes that led to the removal of Justice Gertrude Tokonu as opaque and a travesty of justice. That is what the objections has been about, leading to the break, and gradually they are now returning to the committee, taking their seat. I saw in a flash the chairman of the committee, Honorable Bernard Ahiafo, but he's not made his return to the committee room yet. We're waiting on him to come back to take his seat at the committee for proceedings to continue. He said that was a coffee break or a cocoa break, but usually when things like this happening, when they go back and go into conclave, the objective is to resolve the issues amongst themselves before they return to proceed. The Majority Leader Mahama Yariga is there. I'm sure you see in your shot there the Majority Whip as well as the Minority Whip himself in a handshake there, another prayer, as well as Roxanne Nelson Echedapamekpo, or the two of them in a handshake there, and they are taking their seats now. Then we're expecting that any moment from now, the proceedings or the voting process should continue or begin properly for us to continue with the proceedings. I see in there Honorable Jerry Ahmed also walking in to also take his seat, and we're hoping that this should signal the fact that they might have resolved the issues. When they return, per precedence, the chairman of the committee would take time to deliver what decision has been taken, whether they've gone to conclave or a meeting to discuss the issues or take a decision, and the exact decision has been taken. It will be officially communicated to members of the committee, and then the proceedings continue. The nominee himself is not yet in. We're waiting on him to come in. The GJA president, Albert Jumfo, has also just walked in and taken his seat there. I didn't see him earlier. Looks like he's now walking in to take his seat and also follow the proceedings in the committee room. And so we're waiting on the chairman, Bernard Ahiafo, and his ranking member, Honorable Alexander Penyumakin, to walk in, take their seat for us to see what the decision has been on the issue and what decision has been taken as far as those back and forth are concerned. And so it's been almost an hour now after that short break, and we are waiting for the committee to be reconstituted for them to proceed. For those who are just joining us, our live coverage of the vetting process of Justice Paul Baffoe-Bonnie, the Chief Justice nominee, to be vetted by Parliament. And after this vetting, the report will be sent to the floor of the House for a debate. The committee will communicate its decision through that report as to whether the nominee has lived up to expectation, and as to whether they have taken a decision on him, as to whether they have approved him or not. The House will do some form of debate where, of course, the minority would still raise their objections over there, and then the Speaker, the House will adopt the report of the committee, and when that is done, the same will be communicated to the President as to the final decision of Parliament on the vetting process of the nominee. For those who are just joining us, the reason we went on the break was because the majority leader, Mama Yariga, has consistently taken exception to some words contained in the opening remark of the minority leader. The chairman of the committee has just walked in. Honorable Bernard Ahiafo has just walked in. The minority leader, per incidents or per convention, at every vetting takes a time to do what he calls an opening remark, where he raised or addressed a few issues. And today, in his opening remark, in the first two lines of his opening remark, use a line to describe the nominee. He described him as a disputed nominee. There, the majority leader took exception, and it led to a back and forth. He went on to also describe the process that removed Justice Gertrude Tokonu as an opaque one and a travesty of justice. The majority leader, Mama Yariga, again took exception to that, leading to the process almost grinding to a halt. At a point, they raised voices at each other. Honorable Mama Yariga's position is that per Rule 103F of the Orders of Parliament, no statement or word must be a derogatory one targeted at anyone who comes before Parliament or the committee. And that is what led to the back and forth, and the House went on a break. The chairman, Bernard Ahiafo, is calling the committee to order now, and let's join him so that the process can proceed. Live here on Joy News, on your TV, on all our social media platforms as well. Let's hear what the chairman has to say.
Proceed. The minority leader was on the floor. About to land, I will give him the floor to proceed to do so. Yes, please, you have the floor.
Chairman, thank you very much. Chairman, it is our view as a minority caucus that whilst there are pending cases by Her Ladyship Justice Araba Isaba Tokonu in court, we as Parliament must not be seen to be acting sub judice of the very issues she is raising in court. We are of the view that proceeding with the vetting leading to the eventual confirmation of a new Chief Justice will not be regular within the tenets of our Constitution. We will see that as a constitutional overreach. Already in our view, Article 1446 provides for an acting Chief Justice in circumstances of vacancy. There is therefore no institutional crisis. There is therefore could continue serving in acting capacity until the courts have provided clarity on whether, in our view, all that is happening does not amount to some. Chairman, it is also our view that for the sake of our country's democracy and rule of law, the grant of 3 weeks extension for the learned Attorney General for leave for extension of time.
Chairman, please. Chairman, this has to be withdrawn. This has to be withdrawn.
Chairman,
please, we heard what he said. You can't sit here and malign a decision of a court. It's not acceptable. It's not acceptable. Please, don't let us keep doing this, and then send the impression out there we are bad people, we are a minority trying to prevent you from. The rules are clear. You've been told the rules severally. Please.
Chairman, I'm sorry. I think that Chairman, we have to help you. With respect, we all know the practice in this house. Leader, you have to catch the eye of the speaker. You have to respect the chair. This attitude of suddenly punching the microphone and speaking, you are our leader. But I think you should have a word with our leader.
Thank you very much.
Seek your consent.
Honorable Minority Leader, be guided and candidly land safely.
Chairman, please.
Yes, Honorable Ayarga.
Chairman, I raise an objection to his reference to a judicial decision and the conduct of a judge. And the rules are very clear. I really don't understand why the minority leader wants me to keep reciting the rules, because everybody knows that the rules are clear. You can't say that about a decision of a court. You can't say that. So he has to expunge that.
Honorable Majority Leader, I have heard you. Honorable Minority Leader, be guided accordingly in proceeding.
Chairman, with respect, what we are saying is that we disagree with the said decision of the court, and it's our right to have a disagreement with the court, most respectfully, especially so when we are of the view.
You see, Honorable Minority Leader,
Chairman,
you can disagree with all due respect with the decision of the court, and when you disagree with the decision of the court, you know how to do.
That's not a problem, but we are making a comment, Chairman, I've held my calm throughout all of this. I gave you my word, proud to this verdict, and I've kept my word. Today in Ghana, you cannot even speak as a parliamentarian to express a view. You will be stopped by the majority leader. I am not attacking the court. I'm saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court's own rulings and say, on this we disagree. What is happening here? Because somebody has super majority? What is happening in
Honorable
this country?
Minority Leader, I will not have a problem. I will not have a problem.
I have not attacked any judge. We've not attacked the court.
This is by way of a question that will give an opportunity for a response. You are making a preliminary comment.
Exactly, that's exactly what. That's exactly what is
being. The rules.
I don't have a problem.
You make your preliminary comment as such.
Very well, Chairman. Thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba Tokono. Expeditious hearing of this matter and a final determination of this matter
rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy. A strategy to ensure that these cases languish undefended, creating space for this right competition to proceed.
Yes, Honorable Ayariga, let me hear you.
Why?
Chairman. I know now and then the minority leader will say that we are politicians and we should be allowed to do politics. Yes, we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where, in the opinion of the Speaker,
Well, vetting has resumed and we're back. The minority and majority leaders are back again bantering about the same issue that sent them on recess earlier on. It's been 2 hours and still counting, and they're back to square one. Currently, the minority leader is trying to, or attempting to, address the House with that same statement that had continuously been rejected by the majority leader, Mahama Ayariga. With me in studio is Faustina Safo, and she's joining me with this live coverage of the vetting of Chief Justice nominee Paul Baffoe-Bonnie. Fausti, so currently we're back to square one.
We are indeed.
Indeed.
Quite unfortunate.
The leaders of the House don't seem to agree or see eye to eye with this particular statement that it seems the minority wants to bulldoze through, to make. But let's get back to Parliament, and we understand that we have the feed now. Let's go back to Parliament and get the latest from the minority leader.
Well, minority leader, with all due respect, we are a house governed by rules.
Sure, but
I can be guided by the rules that enable the speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised, yes, Honorable Anymedo, let me hear you.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, let me, please, I have the floor. The majority leader is not about, but if you are quoting the standing orders that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on motions. What motion are we dealing with here? Now, every committee, ever since I became a member of this house, every committee meeting, people, we start, the chair, the ranking, we come out with preliminary issues before we start the agenda of the meeting. Now, if you raise a question about what I heard other people say that, well, there had been issues, nobody has the right to raise a preliminary issue when the chairman already ruled that he should speak. This is part of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now, we have been here all day. The nominee had not even spoken a word. This objection, that objection, and
Honorable
yet
Kwame Aimedu Entry, you raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
It's not in response. Wow. Chairman, thank you. Oh, very well. Chairman, nowhere in my submission did I impugn improper motives, or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that. No, Chair, he was just talking.
Just address the chair.
No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the ranking is doing is not right. You were given 5 minutes. We spent 15 minutes.
You don't have the floor. Honorable Dafamako, you don't have the floor. Honorable Roxanne Nelson Dafamako, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG applied to the court for leave to file out of time. It is a statement of fact that we as the minority are raising as part of our concerns regarding the constitutional overreach. We are not saying anything less apart from what is in the public domain. So, Mr. Chairman, the majority leader must be restrained. All the confusion is being caused by him. All the confusion, I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader.
Chairman.
With all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman with respect. Chairman with respect. Chairman with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader
Chairman,
before.
Chairman.
Becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where they will come, force you, speak, put on a mic, then you say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very loud and clear. If you disagree with it, you know what to do. Will you proceed?
Don't worry. We are all aware of what this whole thing is leading to. So no problem. Chairman, we the minority hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokono. We believe that the acting Chief Justice wields the administrative power on this matter, and just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither Parliament's ally in political projects. It is a guardian of our Constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee and the country that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any question. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
Woman, compose yourself.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give rights to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with a debate further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much indeed.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Should I respond?
The report is not ready to be voted for. We are not at a stage of approval. So your conclusion is very preemptive.
No, Chairman, let me
respond.
Chairman will respect. Chairman would
this is not what I want you to respond.
No, Chairman,
so
but
I don't want your response
Chairman,
on this.
To the extent that you've raised it, I just need to.
Chairman, please.
I just need to.
Honorable Minority Leader,
Chairman,
you have your day.
Chairman,
you have your day. The two microphones should be off.
Chairman,
the two microphones should be off. With all due respect,
we have registered our position.
Honorable Minority Leader,
that we have rejected. We don't need to vet
agreed on your position.
We reject him, and we
agreed on your positions. Yes. Yeah. When it is time for voting, then you can vote against the nominee. Yes. So we thank you very much, and we wish you a very good luck. Honorable members,
you wish us a good luck.
Yes, okay. Yes. Honourable members, those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we will proceed with the vetting questions. And my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. Be calm and provide answers to these questions. I will start with the preliminary questions by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Before I start my statement, we are expected to be allowed to make a brief opening.
Yes, allowed you be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a justice of the Supreme Court. I've been a justice of the Supreme Court since 11th of June. I think it's the audio. 11th of June 2008. So 17 years plus I've been a Supreme Court judge. Before the 11th of June, for 2 years I was a Justice of the Court of Appeal. Before then I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956. I went to Korongo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979. Entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81. I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, when I was called to the bar and I started practicing law. As a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekende, 1 year in Sekende, and 4 years in Kejetia Chambers in Kumasi, where I practiced with my friend, the late Sir John, until 1988 when I joined the Ghana Prison Service. I joined the Ghana Prison Service in 1988 and I underwent 6 months military training, and I was posted to Sekende. That's where I met my wife. At the time I met my wife, he was also a Bob-no rank person. She didn't have any rank, actually, a sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So I was posted to Yankanta as a circuit court judge, brought to Kumasi. For 7 years I was circuit court judge, and I became high court judge, and then I'm now here. So I've been a Supreme Court judge for the past 17 years, until 22nd of April, when I was nominated to act as the Chief Justice during the period of the turbulence. And I'm here before you as a nominee for the position of Chief Justice. Now, if I may read my opening remarks, now that I've asked the first question.
Thank you very much. So, my Lord, beyond telling us about who you are, you indicated you have an opening remark. We've also seen your credentials. In giving us the opening remark, you should briefly describe the personal values and experiences that you believe most qualify you to serve as Ghana's Chief Justice.
Thank you.
You combine it with your remark.
Okay. Honorable Chairman, it's a profound honor for me to appear before you today as nominee for Chief Justice. The judiciary of Ghana stands at a defining moment. As I appear before you today to be vetted by Parliament, I do so fully aware that this process is not merely a constitutional requirement, it's a national reckoning. My nomination comes at a pivotal moment in Ghana's democratic journey, a moment marked by public skepticism, institutional fatigue, and a growing demand for justice that is not only delivered but deeply felt. As I step into this role, subject to your endorsement, the nation will look to me not merely to preserve the judiciary's legacy, but to renew it. The nation needs a judiciary that does not merely interpret the law, but elevates the nation's conscience. With your guidance and cooperation and that of all stakeholders, I pledge to restore confidence in our judiciary and leave it stronger than I found it. If I'm endorsed by you, I pledge to lead an era of greater transparency, efficiency, and accessibility in our judiciary. I do so mindful of the constitutional role of the judiciary, not as a political actor, but as a guardian of rights, checks against abuses, and final arbiter in the rule of law. I propose to anchor our transformation on 3 pillars: procedural clarity and predictability, efficiency and accountability, and open justice. If confirmed, I will stand with every judge, every staff, every court user, and every citizen in the belief that access to justice should not depend on who you are or your connections. The Constitution entrusts the Chief Justice not only with judging cases, but with guarding the credibility of justice itself. My task, if confirmed, is to ensure that the law remains both a shield for the weak and a restraint upon the powerful. With your guidance and cooperation, I pledge to restore confidence in our highest institution and leave it stronger than I found it. Now I am ready for your questions. Throughout my career, from prison service through the Internal Revenue Service and the Judicial Service, where I've been for the past 33 years, I have integrity. I've believed that everything that I've done as a judge has been done with integrity, honesty, and impartiality. I have charted a course of adjudication that believes that the law should be the law for everybody. And that it doesn't matter who you are and what you are. Once it comes to the law, it is no discriminator of persons. That has been my abounding lifestyle. And if anybody were to go through any of my files at any of these places, this is what you come up with, that this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamako to ask questions. Honorable Member, you are entitled to 3 questions. You may ask up to 3 questions.
Thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually would be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But I mean, that is on a lighter note. But I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 7 presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years, meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rollins. Then I was promoted in 2000 and I was sworn in together with Secretary Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Baffoe. Then to the Supreme Court by President Baffoe. So if, that was 2008. So if 17 years later, another president deems it fit to elevate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rollins, Mills, Kofo, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Very grateful.
Any further question?
Yes, my lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees. Now, the argument is out there regarding the duration that presidential election challenges take, all the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Will you consider that? That is between the 7th of December and the 6th of January. Will you consider introduce?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of the, as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. in the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that no, there was no need to join any other pledge. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the East. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with a declaration of the new president before the inauguration. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every form that anybody fills with the easy, you have to provide electronic address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, That's granted that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then the trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chopped off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be. And before the inauguration. Thank you.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the lone ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
yes,
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated.
Honorable member, I think you have asked your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dapamako asks question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they will have the opportunity of rising through the ranks and getting to the highest level, because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovely Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidua. I used to appear before her. So that was, and so, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrates. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, as lawyers who were magistrates. But then, around the 2000s, in the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates, but they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. But they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to the chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you find you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with the career magistrates, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as our honorable member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu.
Thank you.
You are entitled to 3 questions. Strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. My Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The illegal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's becoming very, very high, higher as a result of the delays that are occasioned in the courts, so that even small minor offenses in the criminal realm on key. So litigation is now very expensive, and when you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since, and we are trying to find as a matter of fact, with time, which will be able to. I was telling somebody that I had the 24-hour economy idea from time now to introduce courts around the clock, so that we can have night courts. See, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that, and then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term, to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to resolve the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahamaya Yarega, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have. No, we
want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left to, with time, maybe we will get to a 24-hour. I'm certain the president sold his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up. Yeah.
Very well. That is your question number 2.
My Lord, let's still stay within justice delivery. A very important aspect of how we live. Cases on appeal. I mean, previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This, for some time now, has not been working, or it has been suspended. Would you consider that Accra is not Ghana, and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not where we don't have them now. But it is not true that all the other regions have been suspended. No. As usual, we have a Court of Appeal in Kumasi where we have accommodation. So they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, resident there, dealing with cases in the Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated only the Court of Cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central Courts of Appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there is accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member judges, the panels goes to Kumasi, goes to Secondary. The service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidua, if the 5-member group is the same thing, around 40,000 cedis. But you see, going from here to Koforidua is so easy, even though it is risky and inconvenient. It is so short. The Kumasi people found it very difficult to go to Tamale, where they would meet. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now we don't go to Secretary again. We do virtual hearing of appeals for Secretary. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidua. So even if the lawyers in the case are in Accra, they still have to go to Secondary to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Koforidua and Ho. We are trying to get to a situation where lawyers will not go from Koforidua Ho to Koforidua, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in one of the parties could be in Koforidua, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my Lord is getting into virtual stuff. So let's move on to empaneling of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my Lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people suspicious about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the thing that we have fed it with. But, and I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what. But when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory, none of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be the most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7, and we want to believe that this is a matter that we should get the seniors to sit on, then it is done. That can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Tatiba had only 4 months to go on retirement, and since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, we can bring the 6th person in. So AI will be a very good thing for impaneling. Thank you very much.
Yes, Honorable Shaibu, your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased. Whether we like it or not, now people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper, and so I'll be very, very happy if somebody came and Daddy, I saw your picture somewhere. I mean, I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and 2 more cases are added. Then we have situations which I will refer to as institutional. CI 47 was actually passed in 2004. Those of us who were practicing using the older version of the rules, and that was LN 140A of 1948 or 1950, 1960, 1954, LN 140A of 1954. Between 1954 and 2004, when the new CI 47 came, lawyers were always referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2004, CI 47, it was already dead at birth. It was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So in this day and age of when everybody fears for its security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules, and that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials that have been clogged. What we can do is that we should be able to track. Now we have a monitoring team which I'm going to reinforce that should be able, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed a Supreme Court judge, and we were attached to the American Supreme Court. They were surprised that we grant adjournments on the ground of somebody's wife. And a lawyer says, my wife is beat, but we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice? Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. When we say collegial, we mean unlike let's say the State Court, the Circuit Court, and the High Court, we sit in colleges, we sit in panels of more than one. So, and then we take decisions together. There is no, every judgment that is delivered that you read about, even though it comes under the hand of one judge, you can be sure that it has been decided by the panel members. Unless there is a dissenting opinion, it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. The person who is now the president of the court comes from Navrongo. We have somebody from Owa. I went to the best secondary school in Ghana, Koronguduma Secondary School. Somebody went to one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it is a girls' school. Achumamai Secondary School has now become a Fiakobi Girls Secondary School. So he doesn't even know whether he's an old student or what. So,
my Lord, he's still an old student. And the school is still in existence.
And then there is this man who went to school at Koforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her Ladyship, Avril Lovelace Johnson, started from grade 2. Senator Baffoe started from the Regional Tribunal. So both below the Circuit Court where I started. And then there were some of us who joined at the Court of Appeal, like Sir Dennis. Justice Puaman joined at the Supreme Court. Justice Yodi Kulenis joined at the Supreme Court. We have persons who have come from the academia, like Professor Mensabos. So we have different philosophies. This is the Supreme Court. And so when you have all these people with different backgrounds having to come together and then agree on something, even with all due respect, you see how lawyers agree or disagree. The little that we saw from the Honorable Deputy Speaker, Honorable Minority Leader, and Honorable Majority Leader, 3 very able lawyers agreeing or disagreeing on the rules, the standing orders. it shows that perhaps we come from different backgrounds. We will have different approaches to things. It could be our strength, but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this. And you should be able to discuss things formally and informally before things escalate. You should be able to do this. Even empaneling can create problems among you when somebody feels that this man is not being empaneled. I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice. I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all these. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Lodi Kulendi, Justice Poaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was a Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Football was a junior to my very, 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 very good friend called O2SL, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges that makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Haji Aladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons. Because recently, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So will you consider ensuring that the tribunals come up basically at all the best places that you can think of, so that such cases would be handled or fast-tracked? Thank you.
Yes, my Lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engaged you to ask questions about the prison service. This is something that I know about, because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in some prisons was built, the capacity for some prisons is 851. As of today, they are 3,562. A variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, they are 1,727. And this is replicated all over. The prisons are choked. The prisons are choked. Remand prisoners, I mean, it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then there are also some, as you said, who have committed minor offenses, who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year they have not actually even sat. It is something that I want to reignite, revamp it, so that we can have the Justice for All back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, hey, if this man had even pleaded guilty and he had been convicted, he would have spent only 3 years. But because he pleaded not guilty, he is on remand, and his case is not being tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. The main condition a judge looks at is this man I'm releasing on bail. Is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum. He's trying to run away already. The man has been granted bail once and he didn't appear. And so if a judge decides that, no, a person like that, I'm not going to grant you bail, it doesn't matter the offense that the person has committed. The judge may not grant bail. But even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand short for them, and they will be there. So while admitting that there are some people who shouldn't be there, there are also some people who are there because they have to be there. And honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. Her mother was a Catholic. And you know, these old ladies, how when they said, in my time, the Catholic priest was a white person. So at the end of the year, my mother wants to go and then harvest a particular plantain that he has nurtured over the year. My mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree. In our place, we call it in Conqueniasi, playing draft. Every day, my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When a magistrate at also decides to send the boy to prison for 3 years, we sit in Accra here and say the man stole only a bunch of plantains. Do you know what it means what the bunch of plantains means to my mother? It's like stealing your car. You see, so, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family would be the first one he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes. There are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Insawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole, or around the courts, that are other people. So community sentences should be introduced. But that one is in your bosom. It's a law. That one will have to be taken up by you. People should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted paroles may not even be able to go beyond a certain distance because he has a tag that gives AI alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing our pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person, you said to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. I want to ask my last question.
Thank you very much. Proceed to ask your last question.
Mr. Nominee, during your presentation, you mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal courts. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way monies have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north, to ease problems of our people having to travel these distances?
Yes. Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10. a day, sometimes the whole week. It is not, when we tried the Court of Appeal in Tamale, we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible going to, having 5 judges stationed at Tamale to take care of the North. It is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. In a matter of time, we have found ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi and they will be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Ade. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best. May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected and to the best of your knowledge and to the development and progress of Ghana.
Thank you very much, Honorable.
Have a blessed job ahead of you. Thank you.
Thank you so much.
Thank you very much. We shall resume our seats exactly 10 minutes after 5 o'clock.
Thank you. Stay with us here on the Draw News channel. Well, this afternoon, all eyes are on Parliament's Appointment Committee. They have already begun the vetting of the Acting Chief Justice, Paul Baffoe-Bonnie, for the substantive position as the Chief Justice. Well, if you just tuned in, proceedings briefly hit a snag when the committee was forced to go on recess and hold a closed-door meeting just to iron out differences after heated exchanges between the minority leader, Alexander Fayo-Markin, as well as the majority leader, Mahama Yariga, over the former's choice of words. Well, the minority leader had described Justice Baffoe-Bonnie as a disputed nominee. And that remark by the minority leader was objected to by the majority leader, and he demanded an immediate withdrawal. Well, the disagreement quickly escalated into verbal sparring match, and it prompted the committee chairperson, Bernard Ahiafo, to call for a recess. The MPs returned to their seat, and the minority leader continued his speech, but just to tell us that the minority will not be part of the process. In fact, they tell us that they will not examine the acting Chief Justice. And they stated categorically, really, that they have rejected the nomination of Paul Baffoe-Bonnie. They also stated that they wanted the records of Parliament to show that the report of the Appointments Committee is just a majority report. They then staged a walkout. They held a news conference. We'll tell you all about that news conference, some of the concerns they have raised. We also know that the vetting process resumed. Only the majority side of Parliament was cross-examining the acting Chief Justice, who is being nominated for the substantive position. Well, the acting CJ was asked quite a number of questions. First, started by giving a brief background of himself, his career, his journey so far. Well, he described himself as an honest man, a man of integrity and fairness. He affirms that he has what it takes really to lead the judiciary. And right now we know that the House has gone on a 20-minute break. We'll be taking you back there once it commences. We'll also be touching base with my colleague James Abeji, who's on the grounds for us, and also engaging the minority as to why exactly they decided to stage a walkout. Now, if you have been monitoring the Joy News channel, the minority leader, a couple of days back, was on PM Express with Evans Mensah. He assured that the minority will not walk out from the process. They'll be part of the process. What changed? Those are questions we'll be putting to the minority here on the Joy News channel. My name is Faustina Safo. Please stay with us.
Uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, Mommy.
I'm the second coming. Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Troll from Kaswa dear. Why won't he be late? Or be late?
Of course.
Be the luckiest, go be from Georgia, be luckiest. From not the because she be luckiest. Yeah, you go be luckiest. No matter what you're luckiest. Everybody go be the luckiest.
That's Kwame!
Send your God up, boom. If you're poor, what's that? So would the coming of the Son of Man be.
Hey!
Is that his car?
Ha! Even now, your shadow the way designer.
I use my own mouth to reject him. Oh, this is my mouth. Look at that.
Kwame, my son. Now, tell me the truth. How did this all happen?
Oh, Mommy, simple direction. Mr. Goodluck no me well. Yeah, Mom.
Easy qua. Or dial star 712 hash. The devil is a liar. He picked his ticket and entered his lucky 5-digit number.
I'm his birthday.
Oh, how romantic.
And he followed the prompt, yes. And then boom, confirmation test.
One quick, pick 5 numbers for me, okay? I'm feeling like 7.
Star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompts and let destiny handle the
You see how they love you now?
Yo, do you have family before December, may release a motivation album. Patapa, my super.
This promotion is regulated by the NLA on the Caritas platform.
Good morning. Morning. Boss, what do you defend you, man?
Oh, I don't do that.
What do you defend you?
Debut.
Oh.
Oh,
Finn, what's all there?
Got a stubborn cough that just won't quit? The Fendral Cough Expectorant is here to help. Breathe easy again with the Fendral. Relieve cough and treat common cold fast with the Fendral Cough Expectorant. Breathe easy, feel better. Not recommended for children below 6 years. This advert is FDA.
Dreaming of your own home? Thinking of upgrading your space? Then it's time to stop dreaming and start building with the Republic Bank Love FM Habitat Fair 2025. From Thursday 27th November 2025 to Sunday 30th November, all roads lead to the Kumasi City Mall for the biggest housing event in the Ashanti region. Come face to face with the biggest names in real estate, banks with flexible mortgage deals, interior designers, home accessory brands, and the very best in building technology. Plus, don't miss our Habitat Mini Clinic where experts break it all down from the first block to the finishing touches. The Republic Bank Love FM Habitat Fair 2025. Financing your dream home. Inclusive, sustainable, and affordable living for all. Make a date and don't be late.
This event is in partnership with Republic Bank. Sponsored by DBS Industries, Syntex Tank, Doormaster, Ayuda App, Superlock, and Prestodia Ghana Limited. Supported by...
Hello, Ghana. It's time to celebrate 50 years of sports excellence. The Sports Writers Association of Ghana, SWAG, will honor and celebrate Ghana's sporting excellence at the 50th SWAG Awards in Accra. Date Saturday, November 15, 2025. Venue Accra International Conference Center. Time 6 p.m. Theme Gold and Glory. A call for change in national orientation and investment in sport. Special guest of honor, His Excellency John Dramani Mahama, President of the Republic of Ghana. Guest of honor, Mr. Julius Debra, Honorable Chief of Staff of the Republic of Ghana. In attendance, Mr. Gianni Mello, President, Association of International Sports Press, AIPS, the prestigious and longest running awards event in Ghana, the SWAG Awards, promises to be an unforgettable night of glamour, excitement, and celebration of Ghana's sporting achievement. Performing is Afro-pop and dancehall star Stonebwoy. Come, let's celebrate our sports legends and honor the best to inspire the rest. For sponsorship, contact 050-701-7001. The 50th SWAG Awards, sponsored by GCB Bank, Gold Board, Tobinco, Stanbic Bank, Ghana Free Zones Authority, National Petroleum Authority, Omni Basic Bank, and Phoenix Insurance.
Thanks for staying with us here on the Joy News channel. Now, let me take you to Parliament. My colleague James Abeji is on standby. Just give us a wrap of some of the key things that have come up. James, one of the most controversial things that have come up today is the walkout of the minority. They held a news conference. What were the key fallouts from that?
Firstly, I would appreciate you come again.
You attended a news conference held by the minority after the stage, the walkout from the committee seating. Just tell me some of the key fallouts from that meeting and what exactly their concerns were.
Well, that minority press conference happened just after they walked out of the committee room, held the presser on the lobby of the vetting committee, and their main concern, it was actually addressed by Honorable Kwame Anyumedu Entry, who attributed their walkout to the majority's consistent interjection into the minority leader's opinion remark. They say that the majority, according to them, were not prepared to allow cool heads to prevail for the process to continue or transit in the peaceful manner it's supposed to. And so that is what has forced them to step out or walk out of the proceedings. There was question about whether or not this was something that was up their sleeves, which they had planned to do even before the start of the vetting process. He rejected that assertion and indicated that they were ready to fire questions on all cylinders until the incident happened. And so they are blaming the majority for their walkout. They stated that this is not the end of the process. They will continue to register their displeasure and reservations about this whole vetting of Justice Paul Baffoe-Bonnie, even when the majority takes a decision on the matter. But as far as the vetting committee record is concerned, they need to indicate that they reject the process and that they don't want anything to do with it. But when the final committee decision, which obviously will be taken by the majority, comes to the floor of the House, they would continue to resist it and establish their reservations about the process. And so those are the key things they have been indicating about the decision to walk out, that it was because they believe the majority was not ready to allow them to take part of the process, with the numerous interjections, according to them, from the majority leader for Sina.
And what do they say is their next line of action?
They will keep that close to their chest. They said they will take a decision on that. I actually asked the question whether they will go to court or why they didn't go to court. You recall that when the matter of the declaration of 4 seats vacant was taken, that decision was taken by the Speaker, the minority led by the minority leader. The majority leader then, Alexander Kwenyumakin, proceeded to the Supreme Court to seek some interpretation on that. Based on that, he moved that the House should suspend its proceedings until the Supreme Court take a decision on that. And so at least they attempted to seek redress in court. And so I asked to seek clarification why they didn't take such step to proceed to court on this matter, despite the Justice Tokonu herself and is in court to challenge this. They said that is not the issue of interest for them. As far as they are concerned, it is the parliamentary procedures they want to exhaust first before they take a decision on that. And so as to what they will do next, they will not disclose, but we are waiting on what next they will be doing, whether they will proceed to court or it will just be a matter of challenging this on the floor of Parliament when they sit next tomorrow or Wednesday for Sina.
Let's go into the vetting proper, which is something we've been looking forward to all morning. Finally, the process commenced. What were some of the key things that the acting Chief Justice said about how he plans to, go about his job if given the nod to steer the affairs of the judiciary?
Well, you talked about him giving us an introduction at the beginning of the vetting process. When he was done with that, after the first question, he made a statement which seeks to tell us what his reservation or reaction is on what proceeded or what has unfolded at the committee before the vetting started. He said he does not understand what the disagreement is about his appointment. He is disappointed in what has happened. Then he made a bit of revelation that he doesn't know whether it is because they are affiliating him to a political appointment, whether that affiliation is because he actually voted for John Mahama in 2013. It is not clear whether what exact vote it is, but subsequently he made the point that as we speak, those who followed the election petition in 2012 will recall that Justice Paul Baffoe-Bonnie was one of the 9 Supreme Court judges who were empaneled in that election petition, which decision was taken somewhere in August 2013. And so he says that as we speak, he's the only surviving member of that 9-member committee which sat on the Supreme Court the case that went to the Supreme Court, election petition in 2012. And so it is not clear whether it is in the process of that Supreme Court voting that he voted for him, or it is in the 2012 election. There's no clarity on that. But he said he does not understand whether the disagreement and his affiliation to political appointment is because he voted for Mahama in 2013. That's the statement he made. And when it comes to the matters of the Supreme Court and empaneling, that has also been part of public criticism of the Supreme Court every now and then, especially on critical political matters. His position is that he's worried about sometimes how the empaneling goes in the Supreme Court as well as the appeals court and other courts. He said, for instance, he was number 2 at the Supreme Court during the tenure of Justice Gertrude Tokonu, but he recalls that he had been sidelined from empaneling for at least 1 whole year when he sat at the Supreme Court. And so he's worried that some of those things breed bad blood amongst the justices of the Supreme Court, especially with regards to how the chief justices empanel justices to sit on matters at the Supreme Court. And so it is one key issue he will take note of when he becomes the Chief Justice of Ghana, to be cautious about who and who he put on cases at the Supreme Court. In fact, he pointed out to the fact that when he came to the Supreme Court first, it was a matter of seniority. Who is the senior? Sometimes they took 2 seniors and then include some juniors to also learn on the job and panel them in that. And so those are some of the key things he would take note of when he becomes Justice of the Supreme Court as far as empaneling is concerned. Then there was the issue about the expansion of the justice system and the fact that as we speak, there are no appeals courts in the north, the whole of the 5 northern regions that encompasses the northern part of the country. There are no appeals courts. It sometimes takes judges to travel from the south or the middle belt, either in Kumasi or Accra, 5 justices to travel there to go and sit on cases, which he said is the same with the western region as well. Sometimes judges would have to travel from the central or even Accra to the western region to go and sit on cases. And that cost the judicial service at least 38,500 to 40,000 Ghana cedis in terms of accommodation and other logistics to move judges from the middle and southern belt of the country to the north to go and sit on cases as far as appeals are concerned. And so he is considering either expanding the e-justice system where the judges can sit in an Accra and adjudicate over those cases, or the expansion of the appeals court to some of those areas to sit on those cases. And so those are some of the innovations he's thinking of. He talks about also doing what he calls night courts, weekend court, or mobile court as part of the government 24-hour economy initiative, so that they can deal with the backlog of cases. In fact, in his words, he said almost every Ghanaian sues or takes matters to court these days compared to the days before. And so the court is inundated with several suits that they need to sit on. And what they will do is to do night, weekend, or mobile courts to clear these backlogs and also help the work of the justice system. So those are some of the key things he's been touching on as far as the vetting is concerned. But largely, it has been focusing on the e-justice system and the expansion of the judicial process or the justice system to cater for more of the cases, especially people in the hinterlands. Firstly, there's also, if you know, a public discourse or discussion about the disparity, quote-unquote, disparity between sentencing of persons who are considered to be influential persons in society and those who are poor people. the bunch of plantain arguments compared to people who allegedly takes money from public coffers whose cases drag over time. But when someone in public opinion steals a bunch of plantain or goat, is sentenced to long years in prison. He objected to that public discussion. He says that sometimes the pain it takes someone, he set an example of maybe his mother taking time to travel to the farm in long distances to nurture a plantain to grow. And just when she goes to the farm to harvest that plantain which she has grown with her toil, someone goes there to go and steal that plantain. The value of such plantain could be compared to someone's car which someone else has stolen. So it is about the value of the item stolen and not about the economic or social status of the person who commits the crime. And so he disagrees with that public discussion about disparity in the sentencing of persons with influence and people who are considered to be poor people who steals food in order to survive. He wants, community sentencing to be upgraded, to be expanded, to be started and expanded so that it can take care of the overcrowding of the prisons across the country. Know that he always set example of his wife, who is a prison officer, who would always complain to him and fault lawyers and judges for the overcrowding of the prisons as we speak. That the community sentencing, if expanded, could limit the number of people who are sentenced and sent to the prison. And so those are some of the things he's been talking about as far as the vetting process is concerned, Fosse.
Thank you, James. Another thing that stood out for me really was his proposal for operating the 24-hour courts. He tells us that already we have the courts operating, some courts operating for 16 hours. And so we're looking forward to that implementation. That is, if indeed he sails through the vetting process. I'll come back to you, James, because a lot is happening. I'm sure when the appointment committee resumes sitting, we'll come to you live. But then let me just run you through some of the key things that have come up. If you just tuned in, the vetting process is currently ongoing, but we know that the chairperson of the appointments committee, he called for a 20 minutes break. They would resume shortly, and I will take you there. But for a woman watching the whole process, I was quite stunned at Paul Baffoe-Bonnie's admiration for his wife, just stepping down from prison service just for his wife to take up that role. Is quite encouraging, and we're looking forward to how other questions will come up. Unfortunately, the minority is not part of the process. They've served notice that they will not be part of this process. They already are disputing his nomination. They still call the former Chief Justice, Gertrude Araba Tokonu, as Chief Justice because they're concerned about the case in court. They are of the opinion, really, that the case should have been heard before the substantive nomination and subsequent vetting of the acting Chief Justice. But let me just run you through the profile of the man at the center of all this and why exactly we're giving him the spotlight today on the Joy News channel. He's taking his turn before the appointments committee. That's the man, Paul Kojo Baffoe-Bonnie. He is one of the longest serving Chief Justice. He told us today that he's been serving for 17 years. And we just have a brief profile of his date of birth, 26th of December, 1956. And he's from Busumchi District. And then when it comes to his educational background, he has quite a rich CV. He went to middle school in Gwaso, also went to Konongo Dumasi for his senior high school. Then it was SSS, and also went on to the University of Ghana in subsequent years. Just looking at the next slide that will come up, where he went to the University of Ghana before going to the Ghana School of Law, and he was then called to the bar in 1983. Quite interesting at that time. I'm sure some of you were not born, but he was one of the individuals that, just like he told us today, played a pivotal role in the whole judicial legal system. If you follow the controversial Atai case, he was the man that presided over that case. Now, he served as a circuit court judge in Kumasi. He was also appointed a high court judge at Nkwanta as well. And judicially, he has served for the past 17 years. He told us today he's one of the longest serving justices of the Supreme Court. For those of you who have questions about his competence, he says he's the man of the job for the job. He says that he has integrity. He was promoted to the Court of Appeal judge in 2006. He was appointed to the Supreme Court by the former President John Kufuor in 2008, June to be precise. And then he was promoted to the position of acting Chief Justice, April 2025. And the minority, we know, they are contesting this. They feel that the substantive Chief Justice that has been removed, Gertrude Araba Tokonu, is still Chief Justice in their eyes. At least that's what they say. They have walked out of the process today. They wanted the records to show and indicates that indeed the minority is not part of the whole process. They've raised questions about the case before the High Court. The former Chief Justice, Gertrude Araba Tokonu, we know, is contesting her removal from Chief Justice. And she's in court, really. She's even in the ECOWAS courts. The minority is of the opinion that the acting Chief Justice ought to have empaneled the judges that will hear a case even before his vetting. They are of the opinion that the whole process is flawed. And so they're contesting this, really. That is just a little more about his profile on your screens. Some of the chambers he has worked with, as well as he has also worked in the revenue collection department as well. He was the deputy superintendent of prisons from 1988 to 1990. He told us that he had to walk away from that position because of the love he had for his wife. Quite touching to hear that. He has also been speaking really today about the use of AI in the courts. And that is quite interesting. We're looking at artificial intelligence penetrating every field. And we're just hearing from Baffoe-Bonnie tell us that indeed, this is something they're looking to consider. How it'll work probably is something we may have to scrutinize further. Now, he also talked about the number of courts operating and the time really it takes to hear cases. He's hoping to fast track the whole process, the entire process. And that's where the 24-hour courts he spoke about, he hopes that his administration, that is, if given the nod to lead the judiciary, is something they'll be looking at implementing. He also spoke about the legal aid system, really, and how there's a need to properly resource them to take up some of these legal cases. But I am told that the appointment committee, they are back to commence sitting. Let me take you there live.
Of the judicial service is going down. A lot of people have a lot of problems with the service, particularly with regard to the fact that cases keep so long in courts. People go to courts hoping their cases hoping that their case will be heard within a very short period. And cases, but there are some now, the average number of years that a simple civil case can stay in court is about 3 years or 4 years. There are some cases that have been in court for so long. There are also criminal cases, as I said earlier, where people are facing trial over a long period. All these affect people's confidence and trust in the service. But as I said earlier, some of them can be tackled because they are institutional problems. Like, we have vacancies for as many as 116 magistrates. We need to fill 116 courts. We don't have personnel. There are some courts that do not have infrastructure. I mean, you go to the courts and then the buildings are in very serious states of dilapidation. I remember last year, the District Assembly, over the past 3 years, the District Assembly Common Fund sponsored the building of about 100 courts, together with their residences. But it's still not enough. We still have some of these courts built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But we also recognize the fact that there are some judges and magistrates who do not put up their best. And all these add to the creation of backlogs. And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforidua, and the reports that they gave us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The way it is that there are some people who, no matter what, who want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases, and that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller," and then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually loitering around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there. Only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, "Oh, that I saw the judge talking to that lady." So it is his sister, it is his daughter, it is his girlfriend. So go and see her. So people give their money to people, and then they don't even, once they have given the money out, they have bribed the judge. They have, they are okay. So such people go about saying that, "Oh, the judges have taken their money." And once the judge has taken their money and they get their judgment, they are okay. But the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad nuts among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline in then we can tackle it. So if we sensitize people about ADR, that it's not every case that should go to court, mainstream court, and we sensitize people about ADR, people will go there, the backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaint unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole, to reinforce it so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people saying that, well, I'm not going to court, I'm going to do what we call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think in about 2 or 3 years, for about 2 or 3 years now, we have a situation where applications that are filed do not have return days. You go there, they say date to be fixed. Immediately so we found there were situations where a case comes before us, an application, even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot because the application, which was actually time-bound, had date to be fixed on it, and it hasn't been fixed for the past 2 years. So immediately I came, I said that one was wrong. So every case that is filed, every application that is filed should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time, and now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce it used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. My Lord, there are persistent concerns out there that the current process of appointing judges and chief justices give excessive influence to the executives. What reforms, if any, would you recommend to make the appointment process more transparent?
Thank you, Madam Chair. I think I'm the wrongest person to ask this question because, as I said, I have had my elevations across political divides. But I think the current system, for us, it follows the Constitution. If the Constitution is going to be amended to give us a different mode of appointment, then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation with the Council of State on the advice of the Judicial Council. And the Judicial Council is made up of persons, apart from 4 nominees of the presidency. We have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, the Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds, and they have contributions to make. And they advise the nomination or the nomination appointment of members of the court up to the Court of Appeal. So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. But then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these three groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these three lists are produced, you find a particular, let's say we want an appointment to the High Court. You will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you'll be a good material, so apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, it goes to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people go through our net at the Judicial Council, less than one or a maximum of 2 may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice, and so with this kind of nomination from these 3 people, how people can talk about political, I can't really understand. With the Chief Justice, the the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the presidency, the president has a say. And at least that is what our constitution says. If Ghanaians believe that the constitution should be changed to give power to other persons, other bodies to nominate the Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honorable members, on this note, we will then proceed to take questions from members of the subject matter committee in line with Order 217. Honorable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asidin, you have the floor. The name is Bede Asidin.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination. And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came out to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment. As part of all that. We have tried to explain that even though...
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the my mic is. My Lord, I want to find out from you. Do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. you asked me whether I think the current arrangement is okay or it should be adjusted. I think that the current arrangement in football, we say if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, you see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, as you rightly said, the nomination and appointment and everything is done by the president. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's why I'm saying that, as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. And that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes.
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
People suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council. If 40 people, names of about the current lists, on the advice of the Judicial Council, 41 persons' names were sent to the presidency, and only 4 out of the 41 names were taken out, and even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on I was pleading with the president that we needed to have these people sworn in so that the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41, recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative. These 37 out of the 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how will I be able to convince such a person that it's not the president actually who put the 37 people there? We did. We only took our advice. So it is not as if people's suspicions are going about that. You cannot go about trying to assuage people. You can't do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes, any further questions?
Yes, Mr. Chairman. My second question, my Lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 154 of the Constitution, 1541, if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. You become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, whatever Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings. Like, as I said, we mentioned the complexities of the rules. We talked about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra, and also even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year. All the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. Apart from the judges, the judicial system is not made up of only Superior Court. 71 have their salaries decided by the presidency through the committee and then parliament. It's tied to normal civil service, civil servants. And worst of all, the judicial service, either from magistrates to the Chief Justice. We are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 730 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judiciary. That should affect the lower bench in terms of salary, in terms of working conditions, because whilst we struggle, whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, as for the magistrates and the circuit courts, the least said about them, the better. Because you go to the most beautiful house, and before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is always to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
That will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee acting Chief Justice for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that They question whether it is proper for you to be taken through the vetting process because there are a number of suits pending challenging the removal of the previous Chief Justice. They are asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing, and as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction, or when there is situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Cito and other things came up and said that that was right. That was, but the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. When we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, President Mahama was declared, and he was sworn in on the 7th of January 2013. it never prevented His Excellency it also didn't prevent the president from performing his things. Went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If judgment should go the other way, and that's the president should step down for Nana Addo Dankwa to take the seat, that would have been the order of the Supreme Court, and would have been enforced by Article 1 and 2. The same thing would have happened in 2020 when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed, and I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice, there's no court order restraining Parliament from processing the nomination of the president.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have cases getting ripe for hearing and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particular constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the case, the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within 2 weeks to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneled. The Chief Justice doesn't, seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. When you file an application for injunction today and they fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching in procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything, and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he'll give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Agyeman. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April 1974, provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you are part of the case. Today we are still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes, I mean,
the court was happy that they had finally resolved the matter. It was basically a land matter, but what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get Honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had cases like that, and I remember there was a time the Honorable Chief Justice.
So basically, my Lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then the Court of Appeal to the Supreme Court. That's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, Honorable Chair, I agree with you, but it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3 attempts to get justice, and if at the 3rd attempt you are not satisfied, you just have to live with that, and rather work on the quality of the courts, so that by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Can we just cut down the number of layers?
That with all due respect, that will be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review, that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body, whilst we have the Supreme Court actually serve as a constitutional court? Because there's too much caseload at the Supreme Court level, which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku, so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the U.S., like South Africa has? What's your thinking in view of the discussions going on about amending and reviewing our Constitution?
Honorable Chair, this is a very interesting trajectory that this question is taking. People will, answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 plus 9, that is 10, as our Constitution provides, and not go up. It's dependent upon the jurisdiction of the courts, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts, where civil cases or whatever, can go all the way to their Supreme Courts. But when you come to the federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal with review jurisdiction, we have appellate jurisdiction as far as the chief justice matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there's a criminal case, Ali Kasida, started in my village at Gozo, and it ended up at the Supreme Court. We have cases, civil cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have magistrate court cases from the magistracy traveling all the way to the Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, have been granted by the Constitution, that a person has a right to go all the way to the Supreme Court, people are prepared to. And now, you see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You find that about 35 of that number of years happened in the lower trial courts. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submissions of the parties, and then the ruling that is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial courts, one, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where funnily, even where proceedings were supposed to be adopted, you will find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, you know, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when the cases were given to me, in one particular instance, a file as big as this, it was scary. But I tried to take my time. I had been assigned by the Chief Justice. I took my time to, as it were, arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement of the writs, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended, and all its documents. But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2, just a view. My Lordship, Paul Baffoe-Bonnie, congratulations.
Thank you very much.
My questions are actually 2, just a view. My Lordship, looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, do you take the view that as a country, Ghana, we are churning out? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair. I think I don't agree. I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are also not overproducing. Actually, you see, if you go into history, I've had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together from 18th century, Mensa Saba and all that, we're not up to 15,000. 15,000. A lot of them have died. A lot of them have migrated. So, last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals, and then private practitioners. That doesn't include those who are even in parties. So you see, if you take the number 5,000 to 7,000 citizens, one lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. The right thing. And we also have situations, the law is such that to have a legal department, and when they say a legal department, not just a lawyer, a legal assembly, House of Chiefs, all the houses of chiefs. So we have lawyers. We actually need more lawyers. If you are deceived by them or plying their trade in Accra, you may be deceived into thinking that there are many, slightly lower than Accra, or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Kofori, they are 100. Honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. The number that we have a maldistribution, geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, they were about 8 in the courtroom. They just, the headmaster of my school, the best secondary school in Ghana, doing at the end of November. Then when he retires, then he will pick his law, he'll go and do galamsey. In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So, my Honorable Chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the general. And then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that...
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question, but Honorable Chair, I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's the federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the Supreme Court, the Constitution of America, of the U.S. That is, they are what we call a constitutional court. So, but Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone or up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We would not be able to work at all. The only thing that we have to, there are 2 things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see
Now, cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. The way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. If we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court. By an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal. Or, for example, criminal cases can only end up at the High Court or the regional tribunals or whatever. Then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honourable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord. Honourable members, I will then proceed to congratulate my Lord on his nomination as the Chief Justice. And before discharging him, recognize and acknowledge the revered guests, which I will do not in any order, but I will start from the guest list of the Honorable Nominee. We have Director General Prison Service, Patience Baffoe-Bonnie, a spouse of the nominee. Then the following people are the children of the nominee: Sandra Elizabeth Baffoe-Bonnie, Major Felix Baffoe-Bonnie, Engineer Eben Leslie Baffoe-Bonnie. They are the children of the nominee. Then we have brothers and sisters: Mrs. Georgina Konedo Kusi, former Council of State member. We have Peter Baffoe-Bonnie. We have Mabel Baffoe-Bonnie. Then nephews. We have Justice Baffoe-Bonnie, Enoch Baffoe-Bonnie, and Dr. Kofi Bonzi. Family, we have Marini Kwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apau, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Anantahini. Forgive me if I don't pronounce it well. Typical Aigbe boy pronouncing three names. Then we have Nana Dr. Abura Boatin, Nyinahini in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King. Reverend Pastor Tete, Assemblies of God. Then we have old students of Konongo Odumasi Secondary School. We have Felix Abuaji, Esquire. We have Justice Kusi Minka, Esquire. We have Koku Chiramantin, Esquire. We have Esuo Yao Benin. We have Captain Collins Fosu. We have Kwame Jebi. We have Kwame Ousu. Honourable members, we also have Marietta Ajewa Brew. The legal counsel to His Excellency, the President of the Republic of Ghana. We have Benedict Bob Derry, Director of Prisons Operations. We also have Francis Omani Ado, Deputy Director General of Prisons in our midst. Honourable members, don't take offense in the event I do not mention your name. At the back, I have Nana Sangba Jafla II, Paramount Chief of Sampa Traditional Area, also representing His Royal Majesty Otumfo Osei-Tutu. We have Nana Baffoe Ajay Chichikra II, member of Asantehini's delegation. Then we have Berima Yao Koda Opong, Monwurahini of Achim Ebuakwa Traditional Area. Then we have Togbi Teprehodo the Fourth. I've eaten the okra, so I can pronounce this one very well. He is the Paramount Chief of Amfuega, the President of the Volta Regional House of Chiefs, President of the Volta Regional House of Chiefs, representatives from the National House of Chiefs, and is also a member of the Judicial Council. Then we have Nana Dr. Abura Boatin, the Chief of Nyanahini. I think I have announced.
No, you haven't. 16.
I've done it. Now, back to the tall list containing the Supreme Court, Court of Appeal, and other judges. My lords and my ladies, I will urge the Hansard Department to capture every name that I have pronounced here, preface it with my lord or my ladyship, if I don't pronounce it. We have Gabriel Poma, Justice of the Supreme Court. We have Avril Lovelace Johnson, Justice of the Supreme Court. We have Richard Ajay Frimpong, Justice of the Supreme Court. We have SKA, my very good friend, Asiedu, Justice of the Supreme Court. We have another good friend, Justice Tanko Amadou of the Supreme Court. We have Ernest Gaiu, Justice of the Supreme Court. We have Henry Kofi, Justice of the Supreme Court. We have Yao Asari, Justice of the Supreme Court. We have Justice Senyo Jamope, Justice of the Supreme Court. We have Justice Bright Mensah, Justice of the Supreme Court. We have Justice Kweku Akabofo, Supreme Court. We have Justice Dennis Ajay, Supreme Court. We have Justice Battles Kujo, Supreme Court. We have Justice Hafizata Amaliboba, Supreme Court. We have Justice Johnson Mbila, Supreme Court. No, member of the judiciary. Member of the judiciary. Yeah, Judicial Council. We have Samuel Afote, Judicial Council member. We have Ambassador Ekuya Sana Danso, Judicial Council member. Then I have announced Togbi Teprehodo already, but he's here again, Judicial Council member. We have Dennis Eyiram Fumi, Judicial Council member. Now we have Georgina Mensah Dacha, Court of Appeal. We have Jennifer Abna Dazi, Court of Appeal. We have Kofi Akrowia, Court of Appeal. We have Justice Pamela Kranti, Court of Appeal. We have Yao Onyamiye, Jacobo, Court of Appeal. We have Shilaminta, Court of Appeal. Gifty Dacham, Court of Appeal. Professor Olivia Anku Chede, Court of Appeal. Dr. Bampuru, Court of Appeal. Dr. Ernest Owusu-Dapa, Court of Appeal. Jerome Noble Nkrumah, Court of Appeal. Anthony Opon, Court of Appeal. Jafta Apau, Circuit Court. Gifty Ajay Ado, Court of Appeal. Olivia Oben Ousu, Court of Appeal. Alexander Osetutu, Court of Appeal, and he's my classmate. Cecilia Davis, Court of Appeal. Mariam Samu, Court of Appeal. Mariam A.G. Jawara, Court of Appeal. Sam Obong Diewu, Court of Appeal. Lydia Osei Mafu, Court of Appeal. Charles Wilson, Court of Appeal. Ms. Rosemary Gezi, Deputy Director, Communication, Judicial Service. We have Mr. J.R. Ampon Fosu, Director, Communication, Judicial service. Honorable members, all the Supreme Court, Court of Appeal, other judges are all my friends. We have Justice Yoni Kulendis, Justice of the Supreme Court. He is also my very good friend. Honorable members, you are all welcome. On this note, I proceed to discharge the nominee after a successful vetting, and to add that my Lord, Acting Chief Justice nominee, would surely hear from the committee. You are hereby discharged. Honourable members, I will ask the members of the committee to remain seated, and I was asked to add that in Parliament we don't clap, but we said here, here. Thank you all for coming.
Yeah, well done. So well done.
So the chairperson of the Appointments Committee officially discharging the acting Chief Justice Paul Baffoe-Bonnie after being grilled for hours before the Appointment Committee. Well, a lot has transpired tonight, and we just transition to Joy News Prime, and we give you our headlines tonight. The vetting of Justice Paul Baffoe-Bonnie descends into chaos as a minority rejects the Chief Justice nominee, vowing to vote against him after staging a dramatic walkout during his vetting, describing the process as a travesty of justice.
We would yield to you to proceed whilst we exit this committee room.
Well, the majority pushed ahead with the vetting of Justice Paul Baffoe-Bonnie, who described the minority's accusation of deliberately delaying the impaneling for former Chief Justice Gertrude Torkornoo's case as populist and mischievous. Also tonight, we go to Ewoya in the central region where the community's dreams are on hold as Parliament's delay in ratifying Ghana's first lithium mining project has left farmers unable to expand, families stuck in unfinished homes, and the community's future uncertain. We'll bring you the latest in our latest series, Hope on Pause, the Lithium Promise. Also tonight, Gold Board and National Security crack down illegal gold trade, arresting 25 people, including foreign nationals, for engaging in illegal gold fabrication and smuggling activities. We also have business and prime sports here on the Joy News channel. My name is Faustina Safo. We are your home of independent, fearless, and credible journalism. Please stay for details. Well, let's let's take you back now to the Appointments Committee. My colleague James Aveji has been there all day and is currently engaging James Agaga. Let's listen in.
Convert the law faculties as we have them currently into institutions where lawyers can be trained, even with respect to the practical aspects of legal education, so that they can sit the bar exams straight away once they are done with the LLB. Okay. And I think that was in line with the responses the Chief Justice nominee gave.
And so, do we get the impression that he will get enough government support in order to get this through for the legal education system to be expanded?
Of course, yes. He would get the support of government. Already, if you look at the manifesto of the current government, you'd find that there are a lot of proposals which are aimed at reforming legal education in our country. One is the scrapping of the law school as we have it in its current form. And that is why I said earlier on that, look, the law faculties would now be transformed into faculties that would also offer practical training, so that once you are done with your LLB program, you are trained sufficiently to sit the bar exam, and when you pass, you're called to the bar.
Your final reaction should be to your colleagues on the other side of the committee who have staged and walked out of the process after that back and forth. What do you make out of that?
Oh, I was very disappointed in the minority for staging that walkout. Look, they came here to score political points. What is this thing about dependency of cases? They went to court and lost in the first instance. They wanted to injunct, first of all, the process of appointing a Chief Justice, and failed. And so at that point, I thought that they would have seen reason and participated in the vetting of His Lordship, the Chief Justice nominee. But they decided to stage a walkout because they came to the conclusion that rather than sit in there and vet the distinguished justice and see him acquit himself well, they would rather stage a walkout and make it look like the vetting was one-sided. But you saw how His Lordship distinguished himself, his wealth of experience, his knowledge of the law. I mean, you can't question any of that. And so for me, the walkout was shameful. They ought to stop playing politics with things that are born out of law. You see, the Chief Justice was nominated in accordance with the law and procedure. You can't fault any of that. So if you decide to stage a walkout merely because you have filed lawsuits at the ECOWAS court, why you want the judiciary to experience a power vacuum? Because you have a suit before an ECOWAS court or even other suits before the Supreme Court. I mean, it doesn't make sense. You know, you can't injunct the president from performing his constitutional mandate. And that is what he did when he nominated Justice Baffoe-Bonnie as the Chief Justice. And you saw how he distinguished himself.
Thank you. And so that's Honorable Mahama Yariga, who is Chairman of Parliament's Defense. Honorable Mahama Yariga, I'm just signing him out as the Chairman, James Agaga, Chairman of the Parliament Defense Committee. Honorable Shaibu is here. Honorable, you've also had the opportunity to put one or two questions before the nominee. What's your general impression about what we've seen today?
The chaos notwithstanding, we had a very successful voting. You could see from the answers provided by the nominee that this was an extremely competent person the president has chosen to lead the judiciary. And so far, so good.
There's been varied issues talking about the expansion of the judicial system to win out the delays of the process. There's been the talk about judicial education and all of that. Which of them stood out for you?
For me, legal reforms has been one of the critical things. And I mean, ever since we left law school, it's been quite chaotic getting the students into the law school. Remember, a question was asked whether we had too many lawyers, and the answer was apt. I mean, from 1877 to today, only 11,400 lawyers have been trained. against a population of 35 million people. And nearly half of these numbers are in corporate world. And so we need more. So legal reforms and legal education reforms is one of the key things. And I'm happy he answered it so very well, that the reforms, my office as chairman for constitutional legal, I'm seized with the matter of legal reforms that will demystify this whole issue of entrance examinations to the law school. I mean, this will be a thing of the past. This is the last entrance examination students will have to struggle to 1,000, 3,000, 4,000 students will have to struggle for just 1,500 seats. And so for me, that stood out very clearly. And then also, I mean, his answers regarding the Supreme Court itself. Indeed, if you see the number of cases that travel right from the lower level to the Supreme Court, that is why the Supreme Court is inundated with issues. So if you could have, I mean, a special court for sure, or if cases could terminate at a certain point rather than all cases getting to the Supreme Court, it's one of the ways that we can reduce the backlog that he has. Generally, he had very great ideas, and you can see that he has a plan to reform the judicial system in Ghana.
My final one would be about your colleagues' walkout. In the press conference, they accuse you of pushing them out of the vetting process by creating a hostile environment for them, not allowing them to have their say as far as their leader's initial comment was concerned. Is that not the case?
Thankfully, the whole world watched and the whole world listened. You see, we sit here and we interpret laws. We don't come here and do politics. If it's a press conference, I'm talking to you now, that's a press conference. But when we sit here, this is an extension of the plenary. So this is Parliament. And we work with rules and regulations. So in the first place, they were the first to even raise an issue of practical experience, of saying that the nominee should be designated as such and not to call the nominee a Chief Justice. Chairman complied. Subsequently, they refused and or failed to follow simple rules because the rules are very clear. We are here under Order 217. On the basis of that, we follow rules. The fact that there is an issue about what we are discussing in court does not prevent us. Nobody and no person can prevent Parliament from exercising its constitutional duty. You can challenge the outcome. That's your right. But exercising your duty, your constitutional mandate, indeed, the exercise we did, there is a constitutional imperative. And that ought to be done. Exactly what we did. So their walkout was just a facade. I mean, they had planned it long ago.
They said you were intolerant because you would not allow their leader to even make the statement before you react to it. Every sentence comes with an interjection from the majority leader.
They had a script they were marking, and we didn't want them to mark that script.
Why?
I mean, apparently, you see, if you come here and impugn the integrity of persons who are not here to defend themselves, that is not tolerated by Parliament, and our rules frown on that. And so if you start that, majority leader will not allow you to go ahead with that. If you mention anybody's name here, the rules of natural justice, basic law, requires that you give the person a hearing. But those people are not here. If you impugn the integrity of a whole committee that was set up by the president, and which is not part of the subject matter. And so these are basic things majority leader was just averting his mind to say, stay off from these tangential issues because they do not help the cause of what we are doing. Clearly that we never frustrated anybody. They had a script that they were marking. They marked it well, and they worked out well.
You reject that allegation?
Oh, no, absolutely. I mean, I think it's just, this is the best time for them to have done what they did. Indeed, they missed a golden opportunity of asking questions. Look at the brilliant nature and way that these questions were answered. They missed a golden opportunity of asking those questions. I'm sure perhaps they will go to the media and now ask those questions.
And so, thank you so much. That's the Honorable Mahama
Shaibu Mahama.
Okay, Shaibu Mahama, and he is reacting. He's the member of Parliament for Daboya Mankaragu constituency. Let me just run you by some of the key issues that's been coming up leading to the completion of the vetting process. The nominee himself have been responding to the minority's position. Those issues about allegations of deliberate delay in hearing the Justice Tokonu case that is currently before the Supreme Court, as well as the expediting of the injunction case, which was ruled out, was brought to the floor or was put before him by the majority leader, Mahama Ayariga, who said he's asking that on behalf of the minority who had walked out. The nominee said on the matter of deliberate delay in hearing Justice Tokonu's case, if that statement was made by a non-lawyer, he would have let it slide. But because it is made by a practicing lawyer, the minority leader, he said that is mischievous and it is also populist. He also rejects the assertion that the injunction was hurriedly determined in that matter. And so he believes that parliament vetting is a constitutional matter, it's a parliamentary duty which it is performing. And so there is no infraction on any constitutional provision as far as that is concerned, and the minority is trying to project. And so those are some of the key things, apart from the conversations about judicial e-justice systems and the expansion of the judiciary. Those are the key issues that have been coming up in the second half of the vetting process for Sina.
Thank you, James Aveji. But if you just tuned in, you're wondering what transpired on the Appointments Committee, the reason why the minority walked out, watch this.
We hear with a heavy heart, but an unshakable resolve to defend the Constitution of Ghana, protect judicial independence, and uphold the rule of law. We gather to vet a disputed nominee for office of Chief Justice of Ghana. This should be a moment of national pride and institutional renewal. Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political.
Honorable Minority Leader. Honorable Minority Leader, just hold it a second. Yes, Honorable Ayariga.
Mr. Chairman, we are here because our rules say we should be here. And the same rules indicate exactly what we can do or not do when we gather here. Order 1237. 1237 says that the conduct of the speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. You cannot raise anything about the conduct of a member of the Superior Court of Judicature of this country in Parliament except by a substantive motion. No substantive motion is before us, and so the ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object.
First of all, the majority leader is clearly acting in bad faith.
When you refer to the nominee as Chief Justice, the minority objected to the reference to the nominee as Chief Justice and said that he is not a Chief Justice, he is a nominee to the post of Chief Justice, and so you must refer to him appropriately. Or acting Chief Justice, because he's also an acting Chief Justice. And an acting Chief Justice is a Chief Justice. Now, he has referred to the nominee as a disputed nominee. Disputed nominee. disputed nominee. You are in court what? Are you in court litigating his nomination? No. Are you in court disputing his nomination? You are not in court challenging his nomination. So to the extent that you are not in court challenging his nomination, there is no dispute about his nomination.
Let me be unequivocally clear. The minority in Parliament objects to and unequivocally condemns the coordinated campaign to subjudicate Ghana's judiciary to political domination. Chairman, the facts speak for themselves.
I object again.
On the 22nd April,
I object again, Chairman.
On 22nd of April,
I object again.
2025.
Chairman, I object again. I object.
We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any question. We reject the nomination, and the records should reflect that the report of this committee be a majority report. We cannot be part of a process that would give rights to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room.
Well, that's what transpired today. During the Appointments Committee sitting, the minority staged a walkout. Though, if you have been watching PM Express, the minority leader sat here and assured that the minority will not boycott the vetting of the acting Chief Justice, Paul Baffoe-Bonnie. You're still watching Joy News. We'll be back with more. Please stay with us.
As soon as my son gets back from school, he's going to scatter everything. As soon as I walk in, my daughter is going to pounce on me and talk non-stop.
She's developing a fever.
Mommy, my head aches.
When aches, pain, and fever bring your children down, trust E-Panel to help them bounce back. E-Panel paracetamol syrup provides relief from aches, pain, and fever amongst babies and children from 6 months to 12 years. Tough on pain, easy on the stomach, great taste with quick results.
She's back! Daddy!
E-Panel, no pain, happy again. Also available in strawberry flavor, manufactured and distributed by NS Chemist Limited. This advert is FDA approved.
How may I help you today?
We'd like to open a bank account.
Sign here, sign here, sign here, and here. And now you draw direction to your house. I need your thumbprint. And I'll need your birth certificate too. No, I need the original.
A lot has changed since you bank like this. So have we. We've made it easier than ever to open an account online and bank on the go through our mobile app, online banking, and more. EcoBank, a better way to bank your way.
Sign here, and here.
EcoBank, the Pan-African Bank.
After touring all 15 regions, the 2025 Springboard Roadshow now heads to Accra for the grand finale. A national celebration of innovation, inspiration, and the unstoppable spirit of Ghana's youth. Join us on Saturday, 22nd November at the Ohene Kunedu Auditorium, UPSA Accra from 9 a.m. The Springboard Roadshow is brought to you by the Ghana Growth Program, an initiative of the Mastercard Foundation in partnership with the Springboard Roadshow Foundation and its consortium partners, with support from Absa Bank, the Multimedia Group, and Graphic Communications Group. Springboard Roadshow 2025, connecting young people to agriculture, agribusiness, and ATVET.
How may I help you today?
We'd like to open a bank account.
Sign here, sign here, sign here, and here. And now you draw direction to your house. I need your thumbprint. And I'll need your birth certificate too. No, I need the original.
A lot has changed since you banked like this. So have we. We've made it easier than ever to open an account online and bank on the go through our mobile app, online banking, and more. EcoBank, a better way to bank your way.
Sign here, and here.
EcoBank, the Pan-African Bank.
Mommy too, so refreshing. Mommy too, hey then too much. Mommy too, so refreshing. Mommy too, calipo, hey then too much. Mommy too, calipo, you can feel I'm Mommy too, calipo, so refreshing. Mommy too. Hey then too much. Mommy too.
Calipo. This advert is FDA approved.
Say please and thank you. These simple phrases can go a long way in showing respect and appreciation. For example, remember to say please when making a request, and thank you when someone does something for you.
Good conduct, great life is brought to you by
Indomie. Tastes great.
Kivo 4-in-1 Gary Mix. It gets everything inside. Champion taste.
Kwame and his uncle are almost here.
Wait a minute. This one too, your friend Kwame.
Wait, Kwame. As in the same Kwame again?
Yes, Mommy.
I'm the second coming. Into all this tension just to reintroduce that broke boy from Kaswa.
Why would you deceive the family like this again?
Now I understand the whole delay. Trout from Kaswa, dear. Why wouldn't he be late? Or being late, of course.
Coffee be the luckiest. Coffee from your job be luckiest. From not them job she be luckiest. Yeah, you coffee be luckiest. No matter why you're lucky, everybody go be that luckiest.
That's Kwame! Send your God up boom! If you put it toy, so would the coming of the Son of Man be. Hey! Is that his car?
Ha! Even now, your shadow the way designer.
I use my own mouth to reject him. Oh, this is my mouth. Look at that.
Kwame, my son. Now, tell me the truth. How did this all happen?
Oh, mommy, simple direction. Mr. Goodluck no check me well. Yeah, mom.
Easy car. Or dial star 712 hash.
The devil is a liar.
He picked his ticket and entered his lucky 5-digit number.
How much baby?
Oh, how romantic.
And he followed the prompt. Yes. And then boom. Confirmation test.
I'm quick. Pick 5 numbers for me, okay? I'm feeling like 7.
Star 712 hash. Choose your ticket. Enter your lucky number. Follow the prompts and let destiny handle them.
You see how they love you now?
Yo, do you have family? Before December, may release a motivational album. Patapa, my super.
This promotion is regulated by the NLA on the Caritas platform.
Hey kids, what is the capital of Argentina?
It's Buenos Aires, Dad.
Do you know what time it is in China?
China's about 8 hours ahead.
Honey, please don't forget to help the kids with their homework.
Who should help who?
Abi, no, Dada.
Calipo, fruit juice drink. This advert is FDA approved.
Hey, Charlie, welcome back. The malaria really knocked you down, eh?
Charlie, no joke. Fever, headache, vomiting, loss of appetite. I couldn't even eat my usual fufu.
You and your fufu. But I hope you got tested before the malaria treatment.
Yes, I did. And thanks to Malatu, I kicked out malaria one time.
When malaria strikes, take Malatu, containing artemether and lumefantrine. Comes in tablets and suspension for effective treatment of malaria.
Great to have you back.
Thank you. No problem.
Malatu is suitable for adults and children. Manufactured and distributed by NS Chemist Limited. This advertisement has been vetted and approved by the FDA.
Say please and thank you. These simple phrases can go a long way in showing respect and appreciation. For example, remember to say please when making a request, and thank you when someone does something for you.
Good Conduct, Great Life is brought to you by
Indomie! Tastes great!
Kivo 4-in-1 Gary mix. It gets everything inside. Champion taste.
Dream. This tote pays 3 salaries. This book keeps 2 children in school. This cream supports 5 households. Every product creates a job.
Afro-quality. Buy African, build Africa.
Once upon a time, in the heart of Accra, a man in his fancy car sought directions. But the Ghanaian way.
Hello, bro. Good afternoon. Good afternoon. Can you please show me where the Presby Church is?
Oh, sure. Go straight. 10 left at the big mango tree with the broken branches with most of the mangoes falling. Right after that tree, there is a water cellar. If you reach, ask there. Anybody will show you.
When the Black Stars take to the field, every Ghanaian becomes a coach.
Why Fatika on to be dribble? The coach must go.
The sacred cue for our beloved Gobe. As we wait patiently, rehearsing the perfect vibe.
Have you at it? Mami Gobe Nubi. The Kokono. One Garino.
These, my dear ones, are some few moments that makes our Ghana truly special.
And as we share these stories, let us also remember a plate of lele rice, connecting our hearts through the flavors of our culture. Lele rice. This advert is FDA approved.
Thanks for staying with us here on Joy News Prime. We appreciate your company. Away from that to other stories, frustration is growing in Ewoya home to Ghana's first lithium concession. For 2 long years, residents have watched their lives stall. Farmers cannot cultivate new lands. Families cannot build homes and resettlement plans remain on hold, all because Parliament is yet to ratify the Ewoya lithium mining project. Emmanuel Chivenu reports in our first episode of our new series, Hope on Pause, the Lithium Promise.
It was all joy in the central region when lithium was discovered within Infantiman Municipality and the Abra Asebu Komankesi district. To the people and chiefs, this was the beginning of jobs, progress and transformation.
This thing is going to benefit us and is going to provide us a lot of jobs.
But 2 years on, that joy has turned into deep frustration. The delay in ratifying Ghana's first lithium mining project has frozen all activities in the Ewoya. No building, no farming, no development, just waiting. Under this tree in Ewoya, young men gather daily. It is their usual sport, once for laughter and plans, now for venting their frustration. All they can talk about is the moratorium and how it has frozen their plans. Among them is Richard Mensah, a father of 4, and Kwabena, a farmer. Both men are struggling to understand how a promise of development has left them with nothing. Richard leads us through overgrown weeds to what was meant to be his family home. Now, just a pile of weakening cement blocks. He points to the red marking sprayed across the block, the official sign of a freeze on all development. He says he and his uncle bought 4 acres to build and farm on, but all that has come to a standstill. Like many in Ewoya, he once worked with Atlantic Lithium, the company that discovered the precious mineral. But when the project stalled, so did his job.
They issue a moratorium on the land. From that day, you can't farm, you can't build, you can't undertake any economic activity. So the mine takes stock of every property from the date of the moratorium. So if you go and do something new after that date, it's classified as spurious or speculative. That is, you are deliberately doing it so that you qualify for compensation.
Richard's frustration is shared by hundreds of residents, all trapped between uncertainty and survival. Not far from Richard's land lives Kwabena, a farmer and a hunter. His story mirrors Richard's.
And now must stop with him to me for Nicase. I'm a busham, I'm land say, Mundona Mundia Abeoso. But my status and midday for Nana, little phono, Ebeka say, Yenjai, a Jumana, They say, of course, you man, I'm mind no be no. Eba ha ye no. Just because I'm betray free her. And the right now, or say your mom, because I'm bash as no. Only eba nice conversation. Accept your decision beyond the maybe.
He had planted plantain before the moratorium, and even that can no longer continue. Like many, he too lost his job when the company reduced operations following the delay in parliamentary ratification.
For 2 years in here, now me one point I'm doing no other ho. That's a me can I talk about compensation. So 2 years no, so me do come do 4 posts now come here me one point na be 5 posts. Oh, this other about me say, and every 6 months to be a media board there na embebie. Ke funa ke sanka. This year me we be high critics and ke me nke se me nya be 3 posts na account. Anka e board there nko. This year me ntumi nya man.
2 years deprivation from undertaking any economic activity. No farming, no building, no project. Everything is no. So we even had to come in to go and negotiate that. Fine. Let them do these petty food crops like maize, like people were going to starve.
In October 2023, government granted Atlantic Lithium a 15-year mining lease for the Woya Lithium project. But before operations could begin, Parliament's ratification was required. 2 years on, that ratification is still pending.
Aban sign nanka bibia also omuye bia omunyamai
ihe we yefun ye ratification no anya lithium for because ye hunde so we ratify ade no lithium for na wo boboa e we yaman no enti ye sre aban de omomadiara na omre lithium for ana here we yaman ye sre bam na won ye den won ratify ade no won famo ye sre aban.
During this delay, a moratorium was imposed, freezing all building and farming within the mining concession. It has left residents like Richard and Kwabena stranded, compensations unpaid, and resettlement plans stalled.
But no company will invest into such a venture when the government itself is not helping by way of what? Giving ratification to it. So when I told them, they understood it, and they saw that it is not the fault of the company.
At the time the lease was signed, the global price for lithium was about $3,000 per ton. Today, it has fallen sharply to around $850 per ton, raising concerns about the project's economic viability. In the lead-up to the 2024 elections, President John Dramani Mahama, speaking at a meeting with the Central Regional House of Chiefs, stressed the urgency of rectifying the Woya lithium project before it risks becoming a stranded asset.
Right now, lithium is the favored choice for batteries for electric vehicles. But if we don't mine it quickly, otherwise, if time passes by, we have what we call stranded assets. You have an asset, but it's stranded. There's no longer any need for it. And so I think that is something, this is a national cause. If that revenue comes, it's going to come to help the whole nation.
With the collapse in the world market price of lithium, there is now consensus. The initial terms of the lease would have to be revised to keep the project viable. In July this year, the Lands and Natural Resources Minister, Emmanuel Amakofibua, told Parliament he has received Cabinet approval to submit revised terms to Parliament for ratification.
The Ministry has notified Cabinet of the company's request, and Cabinet has granted me the approval to present new terms to be considered in a new memo with revised proposal for the consideration of Cabinet and to Parliament thereafter to save the project.
We will not forgive them if they defer it again.
2 years of silence, 2 years of waiting, The people of Ewoya and the 7 other host communities wait for Parliament's decision, believing it could turn their stalled dreams into reality. Whether the promise of lithium brings prosperity or becomes just another lost dream depends on one thing: action. Emmanuel Jivenu, Joy News, Ewoya, Central Region.
You're still watching Joy News Prime. Stay with us, we'll be right back.
How may I help you today?
We'd like to open a bank account.
Sign here, sign here, sign here, and here. And now you draw direction to your house. I need your thumbprint. And I'll need your birth certificate too. No, I need the original.
A lot has changed since you banked like this. So have we. We've made it easier than ever to open an account online and bank on the go through our mobile app, online banking, and more. EcoBank, a better way to bank your way.
Sign here, and here.
EcoBank, the Pan-African Bank.
So, Charlie, the deal there, I almost get her.
Wow. Syntax pipe, as tough as it can get.
You get so sorry with your back, sorry. Oh, what you was a thing. What the kind of way? Well, you can catch it. Hey! Na ampai
between the pie and carbon.
Hey, madam, pipe menu.
Hey, syntax pipe. Me tono. Omo catch am say no one dem pa. Say ye fie, say ye foam. The pipe we bia e ye ne gum.
Syntax pipe.
Why eliki?
Come, madam. From today, syntax pipe in my pipe. No 2 ways.
We need a pipe be na be use.
SINTEX pipe.
Syntax pipe.
In carry water. No hala.
Seeing the Prentex fabric, I like the color, texture. I chose this design. It suits my body type. It means a lot to me to look good in clothes that I wear. I don't care about nobody's opinion.
Maso. Prentex.
Imagine stepping into a beautifully crafted 3-bedroom story, designed for modern elegance and comfort. Welcome to Hillview Villa, developed by Lakeside Estate, your gateway to lifestyle living. We're excited to introduce our stunning new project, the Marlin at the Hillview Villa. It's an innovative home that combines comfort, quality, and luxury. Sitting on a land size of 5,400 square feet in a secure, gated community with quality roads and a children's playground. The Marlin features spacious living areas bathed in natural light, a lavish kitchen perfect for cuisine adventures, and a private outdoor space for relaxation and entertaining. The Marlin provides a floor area space of 220 square meters in breathtaking environments. The Marlin is truly a masterpiece of modern design and sophistication. With our first phase on the market, get ready to make the Marlin your new home. Don't miss the chance to experience the lifestyle living at Hillview Villa. Call our sales experts on 0204775040 or 0204775042. Or visit www.lakesideestate.com. Lakeside Estate, quality homes for all.
Is your tech holding you back? Feeling lost in the maze of outdated gadgets? Relax. Come with me to Comfy Garage.
Don't see. This your tablet from Compu Ghana has really helped me. Now I track my sales like finance minister. Compu Ghana, class and
number one.
At Compu Ghana, we don't just sell electronics, we transform your life. From office to home appliances and more, we have everything you need to step into the future.
Compu Ghana, class in